Well, so I like to mention one item for motion, Lordship. We have filed yesterday and challenging the recruitment process, Lordship. And the last date of submission of application is on 9th. Lordship. Can it be any date before 9th?
Tomorrow?
Oblige.
My lord, this contempt matter, my lord, last listed on 29/10/25, my lord, with a direction to release some, my lord, non-payment of my lord, salary, my lord, to the petitioner. And now it's already, my lord, 2 months already lapsed, my lord. It's not been listed, my lord. So may I pray, my lord, Friday, my lord. Deeply obliged.
May it please your lordship. Lordship, I beg to mention for listing a writ petition for admission for Friday, lordship. The matter relates to termination of service, lordship. Pleadings are completed, lordship.
So what?
Can it be on Friday, lordship?
Termination of service, it can wait. Why do you need it on Friday?
Lordship, then after vacation, lordship. 21, lordship.
19?
Oblige your lordship. Lordship, can it be on 21, lordship? Oblige your lordship.
May it please your lordship. Lordship, I'm praying this matter to be listed my lord, on admission column. The urgency is, my lord, I'm suffering unauthorized suspension, my lord. On the month of February, I was
What?
unauthorized suspension, my lord.
Suspension?
Suspension, my lord. Nothing has been done yet, my lord.
Friday?
Friday, my lord. Deeply obliged, my lord.
Well.
Where is the counsel? Mentions the matter and he's not there. Who is paying for the other side? Notice has not been issued. No, notice has been issued. SP Chaudhary CGC prepares. None has appeared on behalf of the petitioner when the matter has been called. Full stop. This matter was mentioned by the learned counsel, thereby fixing it for withdrawal. As the counsel for the petitioner has not appeared, the matter stands adjourned sine die.
21, Parudre.
May it please your lordship. Lordship, the petitioner instructed us to withdraw the case, my lord. He is not willing to pursue further.
Huh?
The petitioner is not willing to pursue this case further and instructed us to withdraw this case.
What's your name?
R. Karim, my lord.
You're there.
I am there, my lord.
Mr. R. Karim, the learned counsel appearing on behalf of the petitioner, submits that he has instructions from the petitioner for withdrawal of the instant writ petition. Mr. Ms. So-and-so appears on behalf of the BTC. Taking into account the above, the instant writ petition stands withdrawn, closed on withdrawal. Interim orders, if any, stands vacated.
Oblige your lordship. Maybe your lordship. Lordship, I beg to mention item number 20. It was for listing for withdrawal, lordship. I was not the relevant type.
Adjourn Sinadai. It will come up after you or me, everybody dies. It won't come up before that. Why on earth did you mention the matter when it is there? Don't you see it in the list? Your name is appearing.
Lordship, my name appeared,
Then-
but actually due to traffic problem,
What traffic problem? You know it.
I know it, lordship, but there is some delay, lordship.
We'll take
Lordship,
it
you
as,
consider, lordship.
no, not today.
It's-
We'll take it that regular stands adjourn Sinadai, full stop. Liberty given to the petitioner to mention again for listing the matter. You mention again, then I'll give it after 6 months. Then you can withdraw. It is absolutely your fault. I'm
Alright.
not going to allow this.
May I please, your lordship? Herein, your lordship, the petitioner, he has participated in the recruitment process, your lordship, for the post of
This is
constable.
for motion.
Yes,
Wait. What is your case?
my case is that, your lordship, in initial stage in DME, the candidature of the petitioner was rejected on the ground of having found deformity in the chest wall.
Huh?
Chest wall, your lordship.
Ah. Okay.
And
Then,
subsequently,
oh,
the,
deformity in the chest wall.
Yes.
Then,
subsequently, the petitioner was diagnosed in a private hospital, your lordship. That finding is at page 49, your lordship, kindly.
then what do you want?
So the finding of the Fakhruddin Ali Ahmed Hospital, your lordship, completely different with the findings of the review medical board, your lordship.
So did you approach them?
No, there is no scope of approaching, your lordship.
No, you should have approached them, submitted a representation there. Then look here, this has happened. I have another report. Have a look at it.
But there is no scope, your lordship, therefore. After review-
After regular medical test, there is a provision for review medical. He was considered by the review medical board also.
No case.
My case is that, your lordship, as per the medical guideline, your lordship,
It is for what job?
constable, your lordship, constable,
Then
constable GD.
you have to run. How can you run with your thorax not proper?
Page 49 is concerned, your lordship. He has no any abnormality here.
What?
Page 49, your lordship. This is the view.
Tell me one thing. Why after page 49, there is no page from 50 to 60? After page, what is Annexure 5? What is the page number of Annexure 5?
Annexure 5 is a report, your lordship.
Yes, what is the page number?
It is
60.
50, not
Huh?
60, your lordship. 50.
You have not corrected this?
But herein it is 50, your lordship. 50 and the Annexure 6 is there. But
And this is only this is not our expert opinion also.
this is the expert opinion, your lordship.
This is not an expert opinion.
But this opinion is based on, as per report, page 50 and 51, your lordship.
They have looked into it. What is there? Yes.
But as per, your lordship, the guideline, your lordship,
What guidelines?
guideline for review medical examination, Your Lordship.
Hmm.
I just,
Where is that?
I just want to read out, Your Lordship.
No, no, why should I read out? Why is it not a part of the record? Don't you think that it should be a part of it if you are relying on something? Then, no case, bad case.
But in.
What is the instruction you have?
Because, the page 50 guidelines was, it was as per the guidelines document, it was released. It was page 50 of the document. Because from ground class readiness in the superior and inferior vessel segment of the right lower lobe.
Block mole on the left chest wall. Black mole. On the right.
Yes.
So, deformity in the chest wall. And your medical opinion has no signature, nothing. It is just something you have given.
No, page 49, Your Lordship, signature is there.
What is that?
Page 49, Your Lordship.
Ah.
Page 49 signature is there. These are the report, Your Lordship.
Okay, produce this doctor. Produce this doctor before the court. He has given this certificate, na? Produce him.
I'm saying, Your Lordship, the page 49, Your Lordship, the signature is
Any
there.
page
And
48. Produce the doctor. You can't get out like this out there. Who is he? Nobody knows anybody. But user ID patient Vijen Mohanto.
And page 50 signature
Who is
is also
user
there,
ID?
but seal is not there.
This is HRT thorax. Does it say that it doesn't have a black mole at
HR
page 49, page 48 and 49? You see, the opinion which has been given out there says that on the left and the right there is a black mole. Where is it in this opinion that it doesn't have a black mole?
But perusing these two, Your Lordship, page 50 and 51, advice has been given to the effect that the patient is clinically fit at present.
Where?
That is at page 49.
Patient is?
Patient is clinically fit at present examination. Page 49, Your Lordship.
Where?
Page 49. In short
Page
form, it is.
49 is a handwritten document.
This is the. Maybe, Lordship, this.
Which one? Show me that. Page 49.
49.
Annexure?
Annexure 4,
Where is that?
page 49, Your Lordship.
Where?
Herein, patient written in short form PT. PT means patient.
Huh?
PT means patient. In short form, it is written.
No. No case. I think we should dismiss it.
In,
no case
in,
made.
in some. Lordship,
case
may
made out. No
I'm
case.
praying, Your Lordship, only one thing, Your Lordship.
You don't pray.
Since the opinion is completely.
No, there has been a
opinion of the
review
expert is
done there. Why will they go into and look into other aspects? That case.
But in some, in such type of cases, Your Lordship, in the coordinate bench of this court, Your Lordship has.
Fantastic. Go and file an appeal against that.
Since
The
there is.
coordinate bench of the court has, it's the order of Justice Sumitra Saikya,
Yes.
where you have to submit a representation and then go there. Did you submit a representation? Therefore, I asked you. Did you bring
No.
this to the notice? Because you see, you have to understand one thing. This court doesn't have the medical expertise to decide as to whether this particular document is proper or not. You go and file your representation. The non-consideration of a representation can be a subject matter which this court can look into it.
But-
Not this. I'm not going to allow you to do all these things.
But there is.
No,
since
nothing.
there is
You
no
cannot
provision of
ask
filing-
this court to say that kindly look into these two opinions. This is not absolutely within the purview of a judicial review.
But since there is no provision of filing appeal, Your Lordship, therefore he could not file.
Okay, let
the
me dismiss
representation.
it. Go to division
I'm-
bench.
I am at this stage, I am praying, Your Lordship.
Your
let them
name,
file it
name,
within-
name. A.M. Khan, heard Mr. A.M. Khan, the learned counsel appearing on behalf of the petitioner, and Mr. S.S. Roy, the learned counsel who appears on behalf of the respondents. This is an application filed challenging the opinion rendered by the Review Medical Board. There's two of the of what? Of the center, there's CAPPS, CHBSF Patgaon, wherein it has been opined that the petitioner is unfit. Full stop. It is the case of the petitioner. Full stop. The materials on record reveal show that in pursuance to a notice issued for recruitment of Constable GD in the Central Armed Police Force and SSS Rifleman GD in the Assam Rifles and Sepoy Narcotic Control Bureau Examination 2025, the petitioner participated in the said recruitment process. Full stop. While carrying out the medical examination, it was found that the petitioner had a black mole on the left chest wall, as well as also a black mole on the right. And on the basis thereof, the petitioner was held to be medically not fit.
Black mole, your lordship, that is the identification mark, your lordship. But
Okay. It was found that
base
the petitioner was not fit for appointment as a constable GD. The petitioner thereupon requested for a review. Full stop. The review board, by an order dated by the opinion rendered on 19/11/2025, also concluded that the petitioner was unfit on the ground of deformity in the chest wall. It is the further case of the petitioner that the petitioner thereupon carried out certain examination at the Fakhruddin Ali Ahmed Medical College and Hospital, Barpeta. And it is the case of the petitioner that the said medical college and that the register of the said medical college had opined that the petitioner is clinically fit in the present examination. It is under such circumstances that the petitioner has approached this court. Full stop. It is the case, full stop. This court have duly heard the learned counsels appearing on behalf of the parties, and also have taken note of the instructions so placed by Mr. S.S. Roy, the learned CGC, who was asked to obtain instruction by an order dated 17/12/2025. The said instructions, being relevant, are kept on record and marked with the letter X. From a perusal of the said instructions, it has been mentioned that the Review Medical Board examined the petitioner and his HRCT thorax was done at Empanel Hospital, as per which, inverted comma, ground glass haziness in superior and lateral basal segment of right lower lobe, and was advised to follow up. Stop. This could also have taken note of that the petitioner, upon obtaining the medical opinion from the Fakhruddin Ali Ahmed Hospital, Medical College and Hospital Borpeta, had not approached the respondent authorities by submitting a representation, and have directly approached this court. Full stop. This court, in exercise of the powers under Article 2 to 6 of the Constitution, cannot sit on appeal. And more particularly in respect to two different opinions rendered by in respect to various varied opinions rendered by the Review Medical Board as well as the Fakhruddin Ali Ahmed Medical College and Hospital, Borpeta. Under such circumstances, this is not a fit case for entertaining the instant writ petition. Be that as it may, the petitioner is always at liberty to submit a representation along with all the necessary documents before the Review Medical Board. And the Review Medical Board, on the basis thereof, can very well look into the same. Accordingly, the instant writ petition stands disposed of with the following observations and directions. The writ petition is dismissed on the ground that it cannot, number one, in the present facts and circumstances of the case as observed above, this court is of the opinion that the writ petition cannot, this court is not inclined to entertain the instant writ petition. Number two, the non-entertaining of the writ petition shall not preclude the petitioner to submit a representation before the Review Medical Board of the respondents seeking a reconsideration on the basis of medical opinions available with the petitioner. Number three, in the circumstance, any representation is submitted within 7 days from today, the Review Medical Board of the respondents shall look into the same and do the needful as in accordance with law, in accordance with their guidelines.
But herein the date of the review medical, that one will be 22 year lordship. Instead
What?
of 19, it will be 22. Rejection of review medical.
On 22/11.
It is written 19 year lordship.
But it's an item 2 and 3. Has already completed in code number 7 and record transfer to get in the code number 7 one. This was last 2009 to 2025.
It has been submitted at the bar that the matter is part heard before Honorable Mr. Justice Soumitra Saikia. And the records of the disciplinary proceedings is also in the custody of the court master of the said court. Accordingly, the registry shall do the needful.
May it please your lordship. Lordship, this matter pertains to undermarking, your lordship, in the combined competitive services examination, my lord. And in this matter, my lord, on the last occasion, my lord, there is a question, my lord, which is question number numerical 6, Roman D, Roman 5, my lord, which is in dispute, my lord, where the petitioner had written the right answer and he was given, my lord, 0 marks, where he should have got, it is an objective question, my lord, direct answer. My lord, on the last occasion, we had prayed for similar order of a coordinate bench, my lord. Had passed in Rishikesh Das case, my lord, wherein, my lord, the APSC was asked to get instructions as to the we wanted independent inquiry, my lord, because this is an academic question, my lord, like in the case of Rishikesh Das, which was, my lord, upheld by the Supreme Court as well, my lord.
So 1 mark would make any difference?
Yes, my lord. 2 marks actually, my lord. The basic question, basic case of the petitioner is that he scored 901 marks.
Huh?
901 marks total.
901.
901,
So much.
901. And my lord, the respondent number 8 herein, my lord, has scored 901 marks, and that he has come to know exactly same, my lord, and that he has come to know through
This
RTI.
Rishikesh Das matter is of 2018.
Yes, your lordship, and that
This
was
is
went
the
up to-
matter of 2022.
My lord, exactly. So, my lord, this Rishikesh Das, ultimately it went up to Supreme Court and it was passed ultimately in 2022, wherein he was given the his appointment.
So it is in respect to the same,
My lord, it is in respect to the same combined competitive services,
same.
combined competitive, my lord, same.
Then why have you approached this court in the year 2022?
My lord, that is true, my lord.
No, that is the most important
my lord,
thing. Why should I reopen something which is closed?
My lord, if I would
You are a fence sitter.
my lord,
Classic example of a fence sitter.
apart from
That case,
my lord,
fence sitter. You can't be fence sitter.
my lord, but just
Glaring example of a particular matter.
before I-
Because you see, I allow you. What stops everybody else to come?
My lord, in Indir Singh, I'll showcase judgments, my lord. Where in Indir Singh, there's a judgment, my lord, of Supreme Court, wherein, my lord, the court has given, my lord, that, my lord, that if there is, my lord, merit in the matter, then, my lord, should no, the lordship should, my lord, not scuttle away the case, my lord, on basis of delay and latches, because this is a
No,
writ
this is not a delay in lectures, this is a case of fence sitter. You have waited all the while. Rishikesh Das matter went to the Supreme Court. He fought all this while.
Exactly.
Now, the combined competitive examination must have been held in the year 2016 or 17, something like that.
Well, appointments were given in this year 17, my lord.
17.
So 17.
Now, after 5 years, you are.
No, my lord, I can explain that, my lord. 3 years, my lord, explain because of the fact that, my lord, from 2019, my lord, first of all, the petitioner is a person who was actually, my lord, he was saying,
In that case,
he was poor, my lord. He was poor, my lord, and my lord,
poor.
in the sense, my lord, he was educated, unemployed, and he could not.
So uneducated,
And my-
unemployed. So you
and my-
made him clever.
He was.
Who made him clever? No, somebody must have
And
made
there was
him
and there
clever.
was COVID also, my lord.
You were a person concerned.
My lord,
You were a person concerned in Rishikesh Das case.
but I was the counsel. my lord.
Yeah.
And my lord.
So you
also
must
my
have got
senior-
him now and then okay, let us file another
My lord,
case. You
one
can give
thing I
you
want to
similar relief.
My lord, just
The
my lord,
cost of the litigation, how much amount you must have taken charge from him to return it back to him.
no, my lord, I just want to say one thing, my lord. In this case, my lord,
No case,
in
dismissed.
Rishikesh Das, my lord, it has been given. my lord.
Hence it a glaring example.
My lord-
Supreme Court may help you.
No doubt, my lord.
No,
doubt, my lord. Just one
this
thing.
is not a case. Absolutely. Why on earth did you wait for 5 years?
My lord, can I explain, my lord?
No.
My lord, just one thing in the case of Rishikesh that it was given that, my lord, when there is if there is an error apparent on the face of record, if your lordship sees the question, if there is an error apparent on the face of record, and when we back it with
Mr. Pukman, you have to understand one thing.
And-
The moment I reopen this, I'll be reopening many.
And my lord, there is.
Then I have to say that in respect to item number 65,
My lord.
question number 65, look into in respect of all applications. Or should I say that only for a petitioner he should come?
My lord, technically, 2019, from November 19, there was car. I have explained it also. my
There
lord.
was?
There was the car problem, my lord. And thereafter, my lord, from 2020 onwards, my lord, the COVID happened. So because of COVID.
No, 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 no.
my
Tell
lord,
tell me one thing. When it was car was going on or COVID was going on, did he approach you?
He had not approached me, my lord, but he had given
When
representation.
did he approach you?
My lord, we had given representation, my lord.
No,
Yes.
when did he approach
He
you?
approached me, my lord, on the I think 19 to 20, my lord.
So 19 to 20,
But
you
then-
could not file.
My lord, that time we.
Or you were waiting, then let us see what is the outcome in the Supreme Court.
My lord, he was not ready also, my lord.
Huh?
He was not able to contact. He's from Dhemaji actually, my lord. So he was that time.
So far off, yes.
lord,
At that point of time, you didn't have the
and
four
he's,
lane.
my lord, not constrained, my lord. So
Now we have 4 lanes. At that time, the road was bad near Bandodua.
my lord,
Yeah.
floods also, my lord. That's flood affected zone, my
Uh,
lord. And I've explained that, my lord.
Absolutely
But-
no.
My lord, I just want to show the case of this thing, my lord. My lord, demonstratively wrong. Just once, my lord. if you-
All these cases will go,
Lordship,
this
just-
has to be dismissed right away. You are lucky enough that somebody was issued notice also.
Yes, Lordship, because we had prima facie showed that the answer, which was a question which was.
Wrong, no problem with it.
And
Yes,
my-
it was
my-
wrong. There was wrong. No
There were two
problem.
counts. Three counts, actually.
Mr. Pukon, I understand that let us appreciate that item for question number 65, that question was wrong.
Oh,
And the answer was you have correctly made, but you were not given marks.
Because of which.
Let us admit that.
My lord.
But the fact remains that if I open up this issue
My lord.
now, I will have to open this issue for everybody.
But my lord, it will be my lord. I just want to showcase.
Then you may get hold of another one and say, then look here, another person has come.
my
isn't
lord,
it? Where's your
Lord-
senior? So that they dismiss it in.
and my lord, one more
Yes,
thing.
what is your case?
My lord,
What is your case?
no, my lord, first point, my lord, his delay point is to be explained, my lord.
Is it a delay point or a fence sitter point?
Yes, you have had absolutely fancy, my lord. Absolutely.
My lord,
fancy. After 5 years, and the case which was projected in that case, I was in that case, my lord. In that case, the situation is something different, my lord. In that case, is promptly his opposition honorable court. That's why, my lord, his relief was granted, and there is interim order. Now, my lord, already more than 5 years.
No,
passed.
not 5 years, 9 years.
9 years. So that is not been explained. Says that COVID, but prior to COVID.
We do one thing, we
Lordship,
do
5
one
years.
thing, we dismiss his case,
My lord.
take another 20,000 from him as cost,
Lordship, I have not taken any.
and then that cost should be paid back to the petitioner. What do you say?
Lordship,
This is doing justice.
Lordship, in this matter,
For misleading the petitioner out here to do this matter.
absolutely not, my lord.
Absolutely.
My lord, he
You
has,
were waiting for
My lord.
this. You were the person who was assisting Mr. N. Dotto. Then the moment I saw the first name, 2017, it was okay. Then the moment I saw Mr. N. Dotto, this happened long time back.
my lord, but
Then I saw his name.
my lord, can I just explain one thing, my lord?
20,000.
Nine-
20
nine-
no,
my
you
lord.
argue on why 20,000 should not be there. Remaining is
I
okay.
will argue, my lord. I will argue.
Argue on that.
Matter remains
No
that
other no case.
the client, the petitioner who is in here in my lord has scored 901 marks, my lord, and that the person who is the respondent number 8 has scored equally 901 marks. He was not informed. So my lord, rule 56 and rule 68 is automatically violated. That is the first count. Now having
Rule 50
68, my lord. My lordship comes to rule 68,
of
the 2010 rules, my lord.
what does it say?
2010 rules, my lord.
So you give up on 65?
Well, that is 901, my lord.
Do you give up on 65? Then I can proceed.
My lord,
Give up on 65, then I can proceed. Otherwise, I'm dismissing your petition.
she's the question. Revaluation.
65 cannot be
Okay, my
reopened.
lord, then my lord, I want to point out one thing, my lord, before.
Then it will be, I think people must have already got appointed.
Already, my lord, it's long back.
Then
2016.
I cannot touch. Have you made all the people a party?
So my
Have
lord,
you made everybody who is there
both
in the
are, my lord,
select list?
before your lordship, both are before, both have
No, no,
already filed.
all
affidavit.
the people, because now the question would be, no, Mr. Pukon, the thing is, if I have to open 65, all the persons who had participated in the examination, whose 65 was wrong, you have to
My
make
lord,
them a party, issue a
He's
public
a
notice.
ST planes category person, my lord. So ST planes, there are two people who get in. There are two posts only for ST planes. So ST
How many
planes
people
selected.
participated?
So my lord, ST planes only two people have been selected. That is one is the my lord respond number 7, one respond number 8. So our contention is that initially when we filed the case, we did not know the marks of the respond number 7 and 8. So when that happened, my lord, the APSC has given their affidavit, my lord, where they have disclosed in the affidavit in opposition that respond number 7 has scored 907 marks. So respond number 7 automatically is above us. So my case is simple, my lord. I was in a limited point. That's why the court on the last occasion has allowed us still here, my lord. Otherwise, they would have dismissed it. Even I would have not pressed. But my lord,
You are
we-
very sad,
we
you could not finish up the matter
we had got, my
then.
lord, we had scored 901 marks, my lord. My question is my simple, my lord. The petition.
So you would have got 903.
No, exactly. And
I'm not
901.
going to, don't open 65 cannot be opened. Question number 60, without 65 opening, you, if you make out a case, it's a different.
My lord. And 90, my lord, we scored 901, same tally as respond number 8. So as per rule 68, my lord, if your lordship gets the rule 68, if my lord, rule 68 of the 2010 rules which were applicable then, my lord.
Yes.
Affidavit of receipt.
Yes. Where two or more is.
Where two or more candidates secure equal marks, the tie is resolved in accordance with the following principles. Candidates securing more marks in compulsory papers and interview personality tests put together is to be ranked higher. In cases where the marks mentioned at A, that is A, are above or equal, then the candidate securing more marks in the compulsory papers is to be ranked higher. In case where A and B are the same, then the candidate senior in age is said to be higher. Now, my lord, if your lordship comes to the affidavit in opposition, which has been filed by.
So
the
we take it
APS.
as 901
One, exactly, my lord.
without going
So-
65.
Yes, my lord. So 901, my lord, is the marks which the respond number 8 has secured. And even I have secured 901.
Now let
So-
us come back. Where? Whose affidavit in opposition?
My lord, the filed by respond number 1, 2, and 3.
1, 2, and 3. Where? Page?
Page, my lord, just see it. It is at page, my lord. 101, my lord. That with regard to the statements, my lord, you got it? Paragraph 8. That with regard to the statements in paragraph 6 of the writ petition, the answering deponent begs to state that all three, that is the petitioner, respond number 7, and respond number 8 are STP candidates, my lord. The respond number 7, that is Uttam Pegu, secured 907 marks. That's why, my lord, he's actually got it on merit, man. Whereas the petitioner and the respond number 8 both secured 901 marks in the competitive examination. So this is my case, man. So my case is that we have secured both. So why is he eligible more than me? And moreover, my lord, had my question, which is question number 6D5 would have
No,
been.
then the next paragraph
Then,
is
my lord, it is
pertinent to
pertinent
mention.
here in the rule 68 of the Assam, so and so, my lord, provides for solution in case of two or more candidates securing equal aggregate marks. As such, the commission recommended the respond number 8, sector so and so. But he just recommended. There's no reason as to why they have selected him.
So he must have got more marks.
My lord, but where is the exercise now? They have not mentioned anything about the exercise.
Okay, you must be having the records.
They have not done anything.
How much they did, how did you, what is the basis on which you applied rule 68?
Yes, that is. You have mentioned that 108, 101 page.
No, how did you apply 68?
Yes, that action was not with me, my lord, but by applying.
It's a very sad state of affairs, Mr. Mohanto.
No, record.
These
that
are
record-
old matter, 2022
No, no,
matter, you don't have the records. We have the records at 12 o'clock. 12 o'clock? 12:15.
Action we can, but the record will be because.
Because you are making this statement without there being any explanation. So we cannot take this. So we set aside this for reconsideration. Who is paying for respond number 8? Okay, Mr. Mohanto, done. Bad case for you. Let us hear. No case.
You
Come.
have given
No, there is no explanation. How did you apply rule 68?
that line is.
That is not there. So therefore it is not proper. Come. I think it is over for APSC. APSC bad case. Now let us. We interfere with the appointment of respondent number 8. Yes, Mr. Come. You come here to the main podium. Yes. Yes, what did he say?
Regarding petitioner and the equal marker,
Hmm.
others, the contention of the regarding effect, department should have said that the petitioner should run the 90 mark and the qualified. Under plain category. That mark, that ensuring deponent.
No, this they have mentioned it. They have applied to Rule 68. But there is no marks given, nothing, which clearly shows that the APSC have done illegality. Yes. We set aside. We set aside your appointment. Now forget about delay analysis. No. On the question 65, I'm not going to touch it, whatever he may say. But here is a case that it has been done illegally. So we set aside.
That candidate secured. And for the court.
We pass an order also that not to recover any money from you. Whatever money you have paid, you have got salary, okay, you keep the salary with you. Anyways, government of Assam and APSC has lots of money. APSC has lots of money. What para-8? Para-8, there is no mention. Why? No. Kindly come, Mr. Mohanto, kindly come to Rule 68. I've read it. Come to Rule 68.
Case of that in case of by the candidate securing more mark in the written examination has been ranked higher. So my more he probably.
So how much?
That is not mentioned.
So it becomes very easy. Why on earth you did not mention this? 12:15.
They're not possible.
Why?
Because my lord, once they are entered in the office, my lord, it's very difficult to get them to my lord.
Oh, they don't allow inside the mobile phones, I suppose. Then why are you saying that? No, this is the 2022 matter. It's shameful. The APSC has been. The conduct of the APSC is shameful.
Well, no, I want that, madam, yes, nobody should be by injustice, madam. Yes, yeah, I have clearly mentioned that it is getting higher rank, but I have not mentioned the mark, that is correct. Madam. So can it be on 2 o'clock, madam, on that point?
2 o'clock.
Madam,
2 o'clock you get the sheet. How much marks one has got?
got in the written.
No, we do one thing. We have it on Thursday, first item. Thursday, first item. Don't appear. Senior counsel, na? No problem. Somebody else will appear. File your affidavit. How much marks? Thursday. Only date. Otherwise, I'll set aside this. That is the only point.
Only that, madam.
Only that, but on affidavit. On affidavit, how much each person has got, not on the others. I reject his question number 65 now itself by an order. Heard Mr. A. Fukon, the learned counsel, appearing on behalf of the petitioner. Mr. T.J. Mohanto, the learned senior counsel, assisted by so-and-so, appears on behalf of the respondent numbers 1 and 2 and 3. None appears for respondent number 4, 5, and 6. Then why you are not saying? Then respondent You appear for 4. Who appears for 4? So and so appears for 4. None appears for respondent number 5 and 6 on call. Mr. So and so appears for respondent number 8, 7 and 8. 7 and 8. Full stop. The petitioner herein have assailed the appointment of the respondent number 7 and 8 on the ground, primarily on 2 grounds. Full stop. The first ground is that the petitioner was not awarded marks in question number 65, although the petitioner had correctly answered the same. And the second ground being that even assuming for argument's sake, second ground being that even assuming, no, second ground being that even the first ground, the petitioner having obtained 901 marks to that of the respondent number 8, the respondent authorities have, in violation of Rule 68, adopted an unfair and unreasonable and biased attitude, thereby selecting the respondent number 8. Mr. A. Phukon, drawing the reference to paragraph number 8 of the affidavit in opposition, filed by the respondent numbers 1, 2, and 3, submitted that the illegalities on the part of the respondent numbers 1, 2, and 3 is apparent from the fact that said respondents have mentioned that they have adopted Rule 68 of the Assam Public Service Commission (Procedure and Conduct of Business) Rules 2010, but have shied away from mentioning as to how the Rule 68 was actually applied. Full stop. This court have also perused paragraph number 8 of the said affidavit in opposition filed by the respondent numbers 1, 2, and 3. Full stop. It is disheartening to take note of that the respondent numbers 1, 2, and 3 though had mentioned that the petitioner and the respondent number 8 have both secured 901 marks, but they have not mentioned how Rule 68 of the said rules of 2010 was applied, thereby recommending the respondent number 8. Full stop. There is no mention that whether clause A or clause B of Rule 68 was full stop. This court also inquired with Mr. T.J. Mohanto, the learned senior counsel, who represents the respondent numbers 1, 2, and 3, as to on what basis the Rule 68 of the rules of 2010 was applied. Full stop. Though the matter is of the year 2022, the APSC have not provided him instructions in that regard. Full stop. He, however, submitted that an affidavit would be filed by tomorrow on the aspect as to how Rule 68 of the rules of 2010 was applied vis-a-vis the petitioner and the respondent number 8. Full stop. Before parting, this court, full stop. Next. This court further finds it very pertinent to take note of that the petitioner have approached this court after 5 years from the completion of the recruitment process. Full stop. Insofar as the ground number 1 is concerned, it is the opinion of the court that the petitioner cannot be allowed to agitate the said ground on the basis that the petitioner was a clear fence sitter. In as much as the petitioner waited all the while when a litigation was initiated by one Rishikesh Das by filing a writ petition being WPC number 5576/2017. And after the said litigation had ended with the approval of the Supreme Court to the judgment passed in WPC number 55 to the judgment dated 19/6/2018 in WPC number 5576/2017, the petitioner has approached this court in the year 2022. Full stop. In that view of the matter, this court therefore rejects the ground number 1. Full stop. Only the ground number 2 as to whether Rule 68 of the rules of 2010 was correctly applied or not is the question which remains for consideration. Full stop. List this matter on Thursday as the first item. Yes. What is this?
One complication, I'm going to put on a middle of the pen here, everything will be clear.
Page 43.
Determines specific what you have meant by that. D7.
Yes, sir. Here.
The connecting my version.
Phone.
Put it on affidavit dismissal. So we'll close it on that day after this long lengthy order. This is why didn't you mention? Because he will do an RTI. You didn't mention this most probably because he will otherwise do an RTI, fearing that. No, you would have made an RTI in respect to this.
No, my lord. This
No, you have not mentioned also.
Yes, that is true. There
That-
is mentioned the section, my lord, by the question was not.
That's state of affairs. We have it as the first item. We finish it off. Mr. Pukon, your first case is this case is goes because you got 733. He got number 7 got 756 and he got 753. So your case is bad. So you take today and tomorrow, be happy. On Monday, Thursday morning, 10:30, first dismissal of the day.
obliged, sir.
Ah. এখন ভৰাই দিব এইটো।
Wait, please, your lordship. Lordship, for item number 7, lordship, we need to file reply, lordship.
What?
2 weeks time may be given, lordship.
7 is what? What matter is this?
Charges, lordship.
Huh?
Memorandum of charges.
Disciplinary proceedings.
Disciplinary- Yes, lordship. This is
Lordship, what has happened here is memorandum of charge has been issued. They file their reply. After that, they come and challenge us.
Memorandum of charge for disciplinary proceedings. You gotta stay.
Yes, lordship. In item, in 2 matters.
Very well.
No, in
Hello,
7.
let us hear you.
Lordship, we need to file reply, lordship.
In which case you have to
In
file it.
item 7, lordship.
Other
Whether it-
case you don't file, they have to file reply. We won't look
We
into
have to
that.
file
Let us have
It is
this.
together, lordship.
No. Let us argue. When there is a stay order, you want the time, I give you time, but no interim order to continue.
Lordship, there is
No interim order. First of all, this court doesn't understand the very concept of a disciplinary proceedings being stayed. It's absolutely within their domain, unless you can make out a case and within the limits of 482 that it has to be quashed. Are you?
Lordship,
Let us not consider his reply also.
Lordship, there's a project. The grave deals with construction of road, lordship.
Which item you are arguing first?
Item number 5, lordship.
4861.
481.
Okay. What is your case?
So, lordship, all are similar matters, lordship, same memorandum of charges, lordship. What happened, lordship, there was a Vijay project, a project for construction of road way back in the year 2020, lordship. So their lordship,
It's
scheduled,
a Itanagar bench matter.
lordship, item number 7 was filed in Itanagar bench and then subsequently it was
Why?
transferred here.
Anyways.
Because
Yeah.
all are similar matters, lordship.
Okay, very well. Now tell me.
So, lordship, there are 36 scheduled paid laborers were lordship recruited.
Randhir Kumar. So and so Mukha. Two persons are filing together.
2 persons are filing together in item number 5 and in item number 6, one person is there, and in item number 7, lordship, two persons are there.
How many matters are there?
3 matters are there.
Okay. All are connected?
Yes, lordship.
Okay. Argue.
So what happened, lordship? There, the graduate paid laborers, lordship.
Where's your charge sheet? Memorandum.
Memorandum is, lordship.
Page, Annexa 4,
Yes, lordship.
page
Annexa-
29.
Page 40, the article, the statements of articles.
Where?
Page 40, lordship.
Page 31, a statement of article of charge against Randhir Kumar. But why are you filing two persons are filing together?
Yes, their own memorandum of charges, lordship. We have annexed all the,
But
There-
you have been given a separate memorandum of charge for Randhir Kumar.
we have annexed both the memorandum of charges, lordship.
So are you willing that if the petitioner number 1 is being dismissed, no, I'm asking you, is being given the penalty of dismissal, and the petitioner number 2 is also is not given, then both of them will sail together. I think this is the ground for dismissal.
Lordship,
What do you say, Mr. R.K. Dev Chaudhary?
If I proceed differently against different.
Absolutely, it's not heard of. What orders are passed? Let us see. Heard Mr. T. Das, the Land Council, also Mr. U.K. Goswami. Department initiated on the basis of the impugned memorandum. Okay, tell me why the impugned memorandum of charge should be suspended. Impugned memorandum of charge should not be allowed to be continued.
lordship, because no policy decision has been given, lordship.
Huh?
No policy, they have not stated any policy decision, which we have violated, lordship. Initially, court of inquiry was held, then additional court of inquiry was held. Then memorandum, it was, court of inquiry was held, Lordship, on 24/11/2020. Then additional court of inquiry on 12/7/2022, Lordship. Then Lordship, memorandum of charges was filed, framed, Lordship, on 22/24.
Now, what is your ground on challenging the disciplinary proceeding?
Because Lordship, they have not, a specific violation, what we have violated.
Okay, let
Nothing
us see the
specific.
memorandum of charge, article, page 40. Where is the memorandum of charge?
Page 40, Lordship.
Memorandum, 2nd of August 2024,
Second of all.
articles, page 40. That Mukesh Kumar Yadav, presently posted as while posted in so and functioning as so and so, was responsible for recruitment of so and disbursement of share. Said officer, while functioning as officer, entered into an illegal act of fake recruitment. So and so, that during the aforesaid period, is Mukesh Kumar Yadav a party here?
Yes, Lordship.
Where?
Second petitioner.
So there is a strong allegation against him.
Yes, Lordship.
Then, how can the disciplinary
not
proceedings be stayed?
These are allegations, Lordship. These are allegations, Lordship. They have,
Allegation is?
they have violated the CBC guidelines, Lordship. They need to file, the court of inquiry was held, Lordship, on 24/11/2020.
Where is that?
Lordship, annexure. Annexure 1, Lordship.
Page. Court of inquiry to investigate the wreck of so and so with identical names, father's name, their reply, so and so is directed to inquire, investigate and collect evidence. The methodologies, physical check, instance, the court will investigate the allegation levels by Tinku Jha, commandant so and so. Attention to the presiding officer and members for so and so. Okay. Now what is this? Convening order. Master roll, all these people. Recording of statement. Where is the opinion? Revised order, commendation of the directory. The court of inquiry convened to investigate the allegation of irregularities in so and so. The likelihood of forgery of the document so and so, approximately so and so. Madam, I am not satisfied to extend the interim order.
Lordship, Lordship, let it be taken up on Thursday, Lordship.
Let it be taken up whenever it is.
Lordship,
I am
because-
not extending the interim order. Okay, at the request
Let
of
me
the
file-
council for the
let me
petitioner,
reply,
matter
Lordship.
stand adjourned. When?
I'll make it.
After 6 weeks, 10 weeks,
After 2 weeks, Lordship.
after 2
Let me file
weeks.
my reply, Lordship.
Interim order, I am not extending. This court, taking into account the materials on record, is not inclined to extend the interim order. Let us not write that. This is the matter. When? Give a date.
After 2 weeks, Lordship.
Get a date. I am not extending the interim order.
28,
Hmm?
Lordship, 28th of January. The 28th, no.
Okay. On,
Lordship,
no, let it be on a day when I'm not sitting, 3rd of February. Let it be on 3rd of February, full stop. This court, the learned counsel appearing on behalf of the petitioner sought for an extension of the interim order. However, prima facie, this court is not inclined to. This court, however, this court on the materials on record is not inclined to extend
Lordship,
the
let me
interim
explain,
order.
Lordship, let me explain.
You have not made me, madam, you have not been made able to make out a
No,
case.
Lordship, they have not followed the CBC guideline. They have not.
EVC guidelines, so show me where.
Lordship,
Otherwise, you
item
don't have a
five-
case.
Lordship, only item number 5, Lordship.
You lost your chance, madam.
Lordship,
No
Lordship,
interim order.
Lordship, the petitioner will be, Lordship,
Very well, apply. You have already submitted your show cause.
in one matter, we have filed a reply, Lordship.
Ah, no, no case. Not inclined to it. Next.
Hmm. Because if the instruction that the compliance of the election to some. Or take any immediately after vacation, finally.
It's not a short date immediately. We have a long vacation. Short date is 9th.
Since
Short date is 9th.
8, 9, they are taking time.
Huh?
Since 8, 9, 25, they are taking time to file their exhibit,
At that point of time, I did not receive the compliance. Now I have received the compliance.
So kindly peruse the order.
You stock time for 2 weeks for filing reply. Have you filed your reply?
At that point of time, certain facts.
Okay, then if we have not filed your reply, we consider that he has not come before this court properly. So we ask him to appear. Who is the person?
Paying for a short time.
No, we ask these 3 persons to appear.
Day after tomorrow, I'm giving all the information. Officer, day after tomorrow, I'm giving all the information.
List the matter on 9. On who's failing to do so, in the meantime, if no affidavit is filed, this court shall consider passing appropriate orders for personal appearance.
Wait, please, Your Lordship.
What is this?
Filed an IA for recalling the order of your personal appearance because we have complied with the order.
Okay.
The Lordship would kindly.
The order has been complied with.
Yes.
Yes.
Okay. Then we
The
drop the
Lordship
contempt
kindly-
proceedings. We drop the contempt proceedings.
At page 10 of the IA.
Heard Miss So-and-so appearing on behalf, T. Devi,
They do.
learned counsel appearing on behalf of the petitioner, and Mr. K. N. Chaudhary, the learned senior counsel assisted by Mr. T. Kashyap, appearing on behalf of the contemners. Pustab. It has been submitted. Pustab. It has been submitted at the bar that the order dated, which is the order?
Yeah.
Order dated 24/9/2017 passed in
2024,
WPC number,
2024.
where?
24/9/2024.
24/9/2022, 24, passed in
5574 of 20.
5574/2018 have already been complied with. Because of taking into account nothing further remains in the instant proceedings for which the contempt proceeding stands dropped. So consequently, the directions so issued. Consequently, there would not be any requirement for appearance, the personal appearance of the contemners as directed by the order dated 14/11/2025.
If,
The Honorable IA stands closed in view of the order dated.
if. Hearing item 9.
What is this old matter? I've stopped taking bench one for the last 6 months.
Demanded by your lordship to the London Law Appellate Court by framing an issue.
Oh, that matter.
But
Ah.
I am handicapped because
This cannot be a parted now.
No. Yeah.
Your Lordship's order is
Matter before the court immediately upon receipt of the receipt. So it will now go, this was a matter pertaining there, now.
Yes.
I exercise powers under Order 41, Rule 23A. And therefore remanded. This was pertaining, if I'm not wrong, some road.
Yes.
So there was this road, this was a El Pattern Road. Whether your house is on this side or your land is on this side or.
Court,
Ah.
without the land,
Because it was that road was hitting another his land. The El Pattern Road,
whether it is the T pattern or L pattern. L pattern road is there. Whether it is the T pattern road,
you say it is T.
T pattern.
He says it is L.
He has not said anything. Says that they have not exposed anything.
Huh. But anyways, this matter cannot be a part heard.
Your lordship has passed the registration placed in order before this court. Before this court, immediately on this.
Given by the.
Okay, find out. Pustak. Pustak. This court, sir, heard Mr. A.C. Sharma, the learned senior counsel, assisted by Mr. G. Bhardwaj and Mr. S.K. Ghosh, the learned counsel, appearing on behalf of the respondents. Appellant or respondents. Pustak. This court had passed an order on 27/3/2025 in exercise by exercising powers under Order 41 Rule 23A of the Code of Civil Procedure 1908. In pursuance to the said directions, our findings have been given.
Yes.
The findings have been in pursuance to that, the learned first appellate court have rendered its decision on the additional issue so framed and returned the same before this court. Pustak. Taking into account that presently this court is not taking up the roster of Civil Bench 1, Pustak, the registry shall list this matter now before the appropriate bench, taking up Civil Bench 1. You take a copy from there.
Lordship has substantially given the dictation earlier. I want to point out two things only.
Well, here I got the record. Well, my name is not on my lord, it's in the chamber, I can place it at 2 months. I have checked the record, my lord, so far as these documents, my lord, prior to my lord April 2017 or so, those are there. Both certificates, two certificates.
We'll have it on.
But they have annexed, my lord, it is there.
Let's have it after reopening.
Then.
Produce the records. Mr. B. Gogoi, the learned additional advocate general, submits that the records have been, he has received the records. But however, as his name has not been shown in the cause list, he did not bring the records. First, taking into account the above, list this matter again on 21/2026. On which date the records be produced before this court. Pustak. Yeah, the registry shall indicate the name of Mr. B. Gogoi, the learned AAG, in the cause list. What are these? So old matters?
Not extremely old,
Huh?
extremely old, man.
Then what are these?
No, basically they approach this court praying for pay parity. Pay parity. But during the pendency, much water has flown. And my basic case now will be my additional affidavit in reply. Because what happened during the pendency of the writ petition, the 6 CPC came and 6 CPC recommended restructuring of the pay scales. And earlier the posts were like storeman, storekeeper technical, store supervisor, senior store supervisor, and AO. You know, those posts were recasted and new pay scale has been given. And 2 feeder posts were merged and a grade pay of 1900 was given.
Huh?
2 feeder posts, that is storeman technical, storeman and storekeeper technical was merged and given a grade pay of 1900. Now our grievance is that we are entitled for higher grade pay after the recommendation of the six CPC. So that, on the last occasion, my senior, he wanted to get some instructions. What are the pay scales given? Because it was a new development in the affidavit.
This will differ from my friend Marshall. Last occasion, his submission was that we have not been getting the ACP, which is sometimes. On that, I was supposed to give my instructions. My instructions are that Marshall can be getting the ACP, and ACP, and some of them have even earned promotions in the league.
Lordship will kindly take up WPC 2334, my lord. Dalbir Singh Sodhi. Other matters are, my lord, similar. Yes. Here I have filed the affidavit in reply. Dalbir Singh Sodhi. Affidavit from Asil Gaur.
So here you wanted that rate in the nature if area tertiary setting aside and quashing the scale of pay of 5,000 iman sanction to for the post of storekeeper technical in so and so to issue a mandamus directing the respondent to sanction the post of technical in the border repair reserve so and so the pay scale of rupees iman plus border retrospectively from year with all consequential benefits. So only prayer remains is this
Higher grade pay,
higher grade pay.
4200.
Now what happened?
My lord, Lordship will.
Are you entitled to the grade pay?
Yes, Lordship will kindly come to the affidavit in reply, my lord.
No. Well, what is your basis of your case? Indian Bureau of Mines.
The basis of this case is that.
It's on pay
similar-
parity.
Pay parity.
Pay parity, how is it applicable for BSF and Indian Bureau of Mines?
That's true, my lord. That's
Very
true.
difficult.
That's true.
So
But
then your entire case goes.
thereafter, my lord, there were, because after filing of the writ petition,
Ah.
there were developments. Recruitment rule changed, pay scales merged. My lord, for additional affidavit in reply, my
Pay
lord,
scales merged with whom?
the pay, initially, the hierarchy was storeman, storekeeper technical, store supervisor and senior store supervisor. These four hierarchy was.
Mr. Das, wouldn't it come within a fresh cause of action? Because how can you, because you see, your relief is this. Just for example, I grant you also,
I understand.
the first thing the division bench should do is, this is not a part of the writ petition. That is not a part of the relief. Nothing is there. Don't you think that? Your entire case is on the basis of pay parity that's total. You should have got the grade pay of 4,200. Yes, if you have a case out there, come up with a fresh writ petition out there. Liberty, I will give it to you, and you can come up with a fresh. But if there is a change out there, the pay parity cannot be granted. It's a difficult thing to give you the pay parity.
My lord.
So it can be there. So you, in view of that, anything which you are entitled to some additional benefits pursuant to the 6th pay commission.
Yes.
7th. Pursuant to the 7th. I think.
6.
60s up till 2006.
Yes, my lord. 6.
So this is 6th.
Yes.
Now,
Six.
after 7th changed from 1/4/2016, it
Yes.
changed.
Yes. No, in our case, my lord, 1/1/2006, when the 6th pay commission came, 6th pay commission gave some recommendation for restructuring of this storekeeper cadre. So there was a model recruitment rule published by the 6th pay commission. That model recruitment rule also provide for the pay band and grade pay, which was higher than us. So our contention in our affidavit is that
Give me a copy.
yes, ma'am. Put the file upon.
No, to claim pay parity, is your petition out here. Then
2014, it was filed. This was a model recruitment rule published by DOPT. Lordship will
This
find
was
that,
done in 2015.
yes, storekeeper, the cadre was totally changed. It was storekeeper grade 2, storekeeper grade 1, then store supervisor grade 2, and store supervisor grade 1. The entire, there was a restructuring of the post as well as the pay.
Pay remained the same.
No,
The grade
In-
pay changed.
yes, pay been
The
grade pay
grade,
change.
one was grade P in 1900.
1900, 2400,
2400 and
2800 and 4200.
so they have made one as 4200 also.
Yes, earlier it was 1800, 1900, 2400 and 4200.
Here the pay is also different for store supervisor.
Yes, actually, my lord, the storeman post that was abolished and it was merged with SKT, storekeeper technical, and granted 1900 grade pay, and that it was designated as storekeeper 2. So storeman.
So now there are, how is MACP or ACP applicable? Because now you have various posts.
True.
Promotional
What they
post. I
have-
think the
yes.
supervisor post will be a promotional post.
Yes, my lord, we were initially appointed in 1988. Thereafter, we were promoted in 1995 as SKT. Given grade pay of 1900. In 2008, we were given first MACP.
This is a model,
Yes,
not the rules.
no. It was a model recruitment rule published by the DOPT that you have to change your recruitment rule in view of the.
Now have they accepted it?
Look, my instruction is that they have made the change. They have framed the new recruitment rule.
On the basis thereof.
Yes.
Okay, then
So this changed grade pay was not implemented in our case. That is our
but your entire basis is on the basis of the model
model.
rules, but not on the fresh rules.
Look, it was
The rules which have been adopted, have they adopted the model recruitment rules?
yes. My instruction is that Milord, they have changed the recruitment rule, Milord. Earlier recruitment.
Where is that?
Milord,
Where is the adoption?
Milord,
See,
despite
instructions can't help it like
no,
this.
despite my best
Instructions is a rumor. You are saying something in the on the basis of a rumor.
I understand one. That's
This is the case of 2000. There have been so many upgrades. There have been promotions. They have got some benefits. And the norms on which the challenge was made the various network have been given in 2014. I don't think not should that was good as of now.
You cannot say on the basis of model is not implementable unless it is adopted.
This was for him like.
And I can't issue a writ also to them to accept the model codes because that is absolutely within the domain of the department. Can I?
I understand. May I just pray in view of these developments, Milord, I also tried my best to get the recruitment rule. I also instructed the client, but they also somehow could not get it.
Nowadays everything is online.
It's true, but it's not there, no? It's
On
not
the
there.
online you will find out. So we close this for.
Lordship will grant me
We
liberty.
close this for giving liberty that
Fine.
as much water has flown by.
Yes.
So liberty that because the basis on which it is there
Yes.
and the additional affidavit which you have filed, these issues you can raise by filing a separate.
Separated. That's true. That's true.
Was heard Mr. H.K. Das, the learned counsel appearing on behalf of the petitioners in the batch of 4 with petitions. Yes, Mr. Sharma, what do you have to say? Yesterday he was showing me for ex gratia something. Yes.
No, Lordship,
Anything more?
no.
I'll remember it for all times to come. Ex gratia interest. Now I have to apply the Employees Compensation Act 1923.
That is our duty to trouble you.
No,
And
there's a statutory provision.
Yes.
Section 4A3 is a statutory provision by which it is automatic.
Yes.
From the date on which your gratuity or your, not only the employee, just for example, in the cases of gratuity, the moment the gratuity becomes payable, automatically the interest becomes applicable.
Yes.
That's the law.
Yes, yes. And it
Now-
but in the rules also.
In the Act, Payment of
Yes.
Gratuity Act,
Yes,
it is
payment,
there.
sorry.
Similarly, in Employees Compensation Act also, it is mandatory that 9%. 9% is mandatory.
Yes.
You have to give that. There's no quarrel with that. Now he wants that in an ex gratia and shows me a Supreme
Lordship.
Court judgment.
In case of compensation in railways, Lordship, there is no such provision with regard to interest, but there are cases wherein, Lordship, if a person has a
Yes,
valid ticket. and-
yes. If
Lordship.
your first case out there was that, look here, I have been deprived from 2003 and I am entitled to in spite of various representations. So under such circumstances, not only I am entitled to this 5 lakhs, but also I am entitled to interest because of the illegal deprivation. But what was your case, first case? The first case is kindly give me 5 lakhs. Court passes an order, 2023. Then he comes up, same counsel. Same counsel. After 2 years, he says, oh, we got hold of one judgment from Justice Arun Mungia from Punjab and Haryana and one judgment from Division Bench judgment from Delhi High Court, Justice Muralidhar and another, wherein it is given out there that interest is also can be granted. So you also pay. That is it. But I was disheartened by the fact that Mr. Sharma should not have shown me that judgment. He should have shown me, okay, giving it somewhere, it's a different thing. But not
I can
this.
show, Lordship, there are judgments, Lordship. and
Very
that-
well, but not,
they're not
don't
judgments.
apply those type. I hold you in very high regard, and holding you in high regard, if you show me those judgments, you see it doesn't look nice. Anyways, heard Mr. H.K. Das, the learned counsel, appearing on behalf of the petitioners, and Mr. R.K. Dev Chaudhary, the learned DYSGI, who appears on behalf of the respondents. The present batch of writ petitions have been filed, claiming pay parity.
With charge
In
mechanism.
the post, for the post of storekeeper technical in the Border Roads Organization General Reserve Engineering Force with that of the Indian Bureau of Mines, isn't it?
Yes, my lord. Charge mechanic, stroke electrician and overseer.
Indian Bureau of to the post of
Charge mechanic.
charge mechanic. Where is that?
Lots you will find in the synopsis itself also in the pleadings it's there.
Out here, the post of senior technical assistant, senior Iman, 5,000 Iman, 4,200. You are asking for senior technical assistant, Indian Bureau of Mines.
Annexure it's there.
Oh,
but in
general
the
storekeeper,
pleadings-
general storekeeper in,
Yes,
yeah, in the government press for filling up in the Indira Gandhi Rashtriya Uran Academy.
no, government of India press, my lord. That is a
Government.
different,
Filling up a post of deputation in Government of India press.
yes,
Press, na?
press.
With the post of senior technical assistant. You're asking from that, na?
No, assistant storekeeper technical, page 20. serial number 7,
But that is
Bureau of Mines.
2,400.
2400, yes.
But you are asking for 4,200.
No, SKT. I'm sorry, my lord. We were paying
Kindly see your prayer, Mr. Prayer. What is your prayer? You were given 5,200 to 20,200 plus grade pay of 1,900
in SKT,
SKT.
yes.
So now you want that to be SKT 9,300 to 34,800 with grade pay of 4,200, isn't it? That's your relief.
Because this is of storekeeper.
Understood.
We were promoted from SKT to storekeeper. Storekeeper,
No. What is your prayer?
my prayer is that
Read page 18.
issue a writ in the nature of certiorari setting aside and quashing the scale of pay of rupees 5,200, 20,200 with grade pay of 1,900 sanction for the post of storekeeper technical.
So you want that setting aside. Now
Yes.
second prayer.
To
What you
issue
want?
writ in the nature of mandamus directing respondents authorities to sanction the pay sanction for the post of storekeeper technical in the border road organization general reserve engineering force. The scale of pay of rupees 9,300, 34,800 with grade pay of rupees 4,200 retrospectively with effect from 1/1/2006.
Okay, now kindly come to page 20.
Yes, my lord.
You see, these are the two you are saying 1, 2, and 3
Yes,
of
my
Indian
lord.
Bureau of Mines.
Yes, my lord.
Are you therefore are not asking for this assistant storekeeper?
Actually, our pleaded case in the writ petition is that SKT is equivalent to assistant storekeeper.
But then it is 5,200. So your entire basis of your petition goes. How are you asking the relief number 2? You are changing the grade, the pay.
Because in the meantime, some of them were promoted. Keeper. So storekeeper is a higher post that is 4,200. That
No,
is
no,
the
understood. Here also, general storekeeper, you see, what you are asking, government press, 9,300 plus 34,000 a year plus 4,200.
This is equivalent
So
to
this is asking for SKT. Your relief is for SKT, this
SKT.
should be.
There is some anomaly.
Yes.
There is some anomaly.
The case of the petitioners in the present petition is that the post of the storekeeper technical in the Border Roads Organization General Reserve Engineering Force is at parity with the post of Senior Technical Assistant in the Bureau of Mines, as well as General Storekeeper in the Government of India Press. And therefore, the post of Storekeeper Technical in the Border Road Organization General Reserve Engineering Force should be accorded the scale of pay of rupees 9,300 34,800 with grade pay of 4,200 retrospectively with effect from 1/1/2006. Full stop. At the outset, Mr. H.K. Das, the learned counsel appearing on behalf of the petitioner, submitted that pursuant to the filing of the instant writ petition in the year 2014, instant batch of writ petitions in the year 2014, and the affidavit which was filed by the respondents in the year 2015, a model recruitment rules have been framed wherein the post of the storekeeper technical have been what is the word? Have been?
It will be like the storekeeper.
No, have been, what is the word used? Have been redesignated.
Storekeeper.
Has been redesignated
Yes.
as storekeeper 1.
grade one,
storekeeper 1,
storekeeper grade one.
grade 1. And there are further 3 additional posts have been also created. Full stop. And in that regard, an additional affidavit has also been filed by one of the petitioners in one of the petitioners in WPC number 2334/2014. Mr. Arkadeep Chaudhary, the learned DYSGI, submitted that a question of parity does not arise. Parity by treatment with the post of storekeeper technical with other departments of the border security force with the other departments does not arise. Huh? A broader road organization does not arise in view of the settled principles of law as laid down by the Supreme Court in the case of which one? The 2019-18 SCC. What is the name?
SS Bola.
No. 2019-18 SCC.
Mohanan Nair.
That is the judgment of Justice U. Lalit and Justice our Chief Justice, he was there now here. 2019 Bihar, that is the Bihar case.
Well, I'll furnish you.
Where Jagjit Singh was distinguished and said that it is per inquiry in view of not taking into account 2 judgments of the Supreme Court, Constitution bench of the Supreme Court in the year 1964. Is that 2019-18 SCC? Got it. State of Bihar versus Bihar Secondary Education, Secondary Teachers Struggle Committee reported in 18 SCC 301. Full stop. Mr. H.K. Das, the learned counsel submitted that though the petitioner may not be entitled to the pay parity, but in view of the model, recruitment rules which have been adopted by the department to which he has been instructed upon to him, the petitioner is entitled to certain additional benefits, which is, however, are not a part of the instant writ petition. This court have given anxious consideration to the respective submissions and have also perused the materials on record. It is the opinion of this court that taking into account the judgment of the Supreme Court in the case of Bihar Secondary Education, Secondary Teachers Struggle Committee, Mungar and others, Supra, the claim of pay parity vis-a-vis the post of the storekeeper, technical of the border road organization, with that of the senior technical assistant of the Indian Bureau of Mines, or even the government India Press, Government of India Press, or even the general storekeeper in the Government of India Press, does not arise, do not arise. And as such, the relief which have been sought for by the present writ petition, present batch of writ petitions, cannot be granted. This court have also inquired with Mr. H.K. Das as to whether the model recruitment rules as formulated by the Department of Personnel, Department of Personnel, na?
Yes. Department
Government
of
of
Personnel and
India.
Training.
Personnel and Training, Government of India, have been adopted or not. Mr. H.K. Das only submitted that he has been instructed that it has been adopted, but he does not have any notification in that regard. Considering the above, considering the above, it is also the opinion of this court that merely on the basis of the opinion of this court, that first, that merely on the basis of a model recruitment rules, which is yet model recruitment rules, no writ can be issued, since those model recruitments have been adopted by the concerned department. Consequently, the batch of writ petitions stands disposed of with the following observations and directions. Number one, this court does not find merit on the claim of the petitioners in respect to pay parity with the post of, in respect to, to be entitled to a higher pay scale and grade pay, as have been sought in the writ petition, for which the writ petition stands dismissed. Number two, the dismissal of the instant writ petition, however, shall not preclude the petitioners to claim additional benefits if otherwise entitled to under the recruitment rules. First,
Recruitment rules and policy of the central government.
as well as the policy of the central government. Anything
Much
more
of
you
it.
want to add?
No.
That I should give him the right to again to file
No.
and also engage Mr. H.K. Das and MP Sharma in the matters?
Informing him in and he also not got permission.
Huh?
He of the petitioners have been promoted.
Highly obliged. Much.
So old matters. Yes, who is there? You are there. Hello.
Lordship may kindly pass over the matter for the time being. I'm here.
Time being?
Yes,
What is this time being business? What is the matter about?
Order dated 22/10/24, Lordship. It's not stated that it's grievance to redress, Lordship.
The basis is likely to be redressed by the and therefore praise for listing.
No, it has not been redressed, Lordship. They have filed an affidavit. He appears for the Fishery Department probably, Lordship. And they have filed an affidavit stating that it has been forwarded to the Fishery Department, Lordship, Finance Department. But the finance had not considered it. Lordship.
Where is that affidavit? I mean, discharging my duty as the Deputy Director of the Fishery, and I have been authorized to demand. Regard to the parent stated the nature for normalization of the blank post of officers and staff under FPD has been submitted to the request. What is this? Tell me what do you mean by paragraph 6? Read it. Read it aloud. The other people also should know. Read it aloud. Other people should also.
Stated the necessary proposal for nominalization of blank post of officers and staff under FFDA had been submitted by letter number so and dated 26/8/2010. But the finance department regrets the same proposal.
What is that regrets means?
Not-
Regrets means they're sorry.
Sorry. I read as for full notice.
That with regard to the demand, the cabinet member for FDDA post on the statement has been implemented today. Huh? What is the case about?
Lordship, they were required by the department, they were serving under an agency lordship. And
What is your prayer?
lordship for normalization.
What is this
Basically,
normalization business?
Lordship, the agency received grants and we were being paid, everything is being paid to us from the grants lordship, from the government. But it's similar to that provincialization lordship. But the other things lordship,
To
including.
regularize, provincialize the services of the petitioner as a one-time measure with retrospective effect by normalizing the post with all What is normalizing means?
Lordship, basically, the service benefits, they does not get lordship. They are basically like contractual employees only now.
Huh?
Yes, lordship. Because,
They won't get pension.
no, they won't get.
What will they get?
Agency itself receive grants from the government, lordship, and from the grants, we are being paid our salaries, lord.
From the?
From the grants that they receive, the lordship fishery department, from the government, we are being paid, lordship.
So you want your services to be brought within the fold of the government?
Yes, because, lordship.
Because this is very difficult. Regularize and provincialize. Regularize means to bring somebody within the fold of the government.
Yes, lordship. Why I'm saying.
That is regularization.
Yes, lordship.
And as a one-time measure
Yes.
with retrospective effect, which is very difficult, by normalizing the post with consequential benefits.
Lordship.
Means you are asking, on one hand, you are submitting that normalizing, you don't get service benefits. But you want the normalizing, you also want, but with consequential benefits.
Lordship, why
Explain.
I'm saying so, lordship.
Anybody in the respondent who can explain what is the case of the petitioner? The petitioner counsel have not been able to, maybe he doesn't have the brief.
Lordship,
Who is your senior?
my senior was there, lordship, but now one of my colleague, lordship, he was supposed to.
Who is he?
A. Chakraborty, lordship.
Oh, ask him to come by the time, otherwise I'll dictate the judgment.
6/6/24, Lordship, petitioner counsel stated that he has lost the contact with the petitioner, Lord.
Very well. That is why he is not there. Anyways, you try to find out by the time, yes, Mr. Borbudari, what are they asking for? Because this is a 2015 matter, I would not allow this to go another or next date. It would not be proper. Very difficult.
As one-time measure with retrospective effect by normalizing the post with all consequential benefits. Now, these matters, so far as normalizing of post or regularization, these arises out of policy decision of the state. Number one. Number two, so far as retrospective regularization.
Retrospective won't happen.
State of Jammu Kashmir, Bandipora is there. So it says, that retrospective regularization is not permissible.
Retrospective regularization is not permissible. That is not there. But the fact remains that wants to bring it within the ambit of as if he is in the temporary service, more particularly the paragraph 43 or 44 of direct recruit, 43A, that if a person is in temporary service and when he is confirmed, it dates back to the date on which he was being promoted or whatever he is being recruited. So that is what he wants to say, if I am not wrong. But the fact remains that on one hand, when he is asking for regularization, means he himself says that he has not been brought within the fold of the center of the government, services of the government. If he has not been brought within the fold, the question of retrospective cannot be given. But he has the RD's petition is still continuing.
Lordship, at least 20 of them are still continuing.
Huh?
At least 20 of them are still continuing, Lordship.
Continuing. Now, what is the post in which they are continuing? What is the post? Let us see these people. Of centrally sponsored schemes, freshwater, aqua, so and so. Oh, there again that problem arises, na? That another judgment is there, na? What is that? Permission and you've been caught everywhere. Eh? Permission under and there's another one. Earlier matter, na? So there was one paragraph judgment. What was the name? There were two, which you have shown. No. Sakuntala Devi, no. Sakuntala Devi is a new one. There is another one. It's a long judgment, one paragraph judgment, wherein at one point it has also been mentioned that if you are in a centrally sponsored scheme, you are outside the government and you cannot be brought within the fold.
But they are receiving.
Permission under says, another thing, permission under says that these people were actually from Bihar.
Yes.
They came over in a certain scheme. They came over when the Jharkhand was formed. And now they wanted to be brought within the fold of the government. So the question arose out there when they were never inside the government. Where is the question of their being getting the benefit? And that was, what was the judgment? Gyan Singh.
Lordship, but herein they are receiving grants, Lordship, and from that grants they are being paid, Lordship.
Huh?
The agency which recruited them, Lordship, they are receiving grants from the government, Lordship. And
No,
from
they may give grants from the government. They may the central government may also give grants. All these things are there. But this is under a scheme. If we allow this type of repetitions out here, the same thing will be. The question is, why not NHM? These are all contractually appointed.
there is a procedure under that, Lordship, how to regularize if they are appointed.
How do you regularize if it is, you see, there is another thing. If you come within the ambit of those Dharam Singh type cases, wherein these people were there and the question is their services were required and they continue to remain in these contractual jobs or temporary jobs, they have been kept and giving less money out there, this is going on.
Herein, Lordship, what had happened is that some of them had already been regularized, Lordship. And there is the discrimination meted out to us, Lordship.
So you come up with that case, where is that? Some of them have been regularized.
Place that, Lordship, only one day time may kindly.
2015 matter, it doesn't look nice. Okay, 10,000 cost, then only. I can show it to the people also. Na? You see, the public out here is also conscious that 2014-15 decade-old matters are being pending in the High Court. It doesn't look nice.
Professor Nanda, the 11 extracts of Hansi has been quoted. Paragraph 79, I'm reading it out, my lord. The continuous engagement of the appellants under the specific scheme cannot be held to be an employment under any establishment of the government. Such schemes are taken up for certain contingencies when money for the same is provided either by the central government or at times by some foreign countries. but the employment under such scheme is not being a part of the formal cadre of the state government. It is difficult to hold that the period for which an employee rendered service under such scheme can be counted either for the purpose of deciding their pensionary benefits or even for fixing of their salary in the scale of pay once they are regularly absorbed.
And now in permission under another aspect is there. You see, what is there in permission under? I'll show you. They gave me this. Where that the judgment in Baliram Singh has it in final Dhyan Singh. Yeah. Yes, paragraph 21 of permission on there.
31 of the pension rules have been dealt with.
These are ours also 31.
Absolutely, pay criteria. Same
The
parameter.
three requisites.
Substantial post to be paid by the government. Number one is my lord, the.
And the governor can do away with 1 and 2, but not 3.
Not information of the, that was the exception that has been carved out.
No, in the proviso to Rule 31, 1 and 2 can be taken care of by the government, but not 3.
Because the governor.
As regards non-payment by the state, can also be taken care of by the government as an exception. That case,
That angle, Lordship, it's.
where is Mr. A. Chakraborty? I waited for such a long time.
Lordship,
You said 5 minutes. I've given you 10 minutes.
Lordship, I don't know Lordship where he is, but Lordship, he said he will come probably. Lordship is stuck up somewhere, Lordship. Can it be taken up in the second half, Lordship? Second half.
Second half? Second half, you have a meeting now? Don't you think so?
Yes, Lordship.
You're having a meeting from 1 to 3 o'clock? You only say, I never said so. Isn't it the request of the bar that from 1 to 3 don't dismiss our cases? Huh? Specific request has been made for me. Huh?
Again, we have also got reference,
And the
Lordship.
chief has to specifically request me that accommodate the bar. Then you are wanting at 2. How the, isn't it contrary to your association's thing?
Lordship.
And you don't have the file.
I'm sorry for that, Lordship.
What is the finance department stand? They have not filed. What is normalization of a post, Mr. Arya?
Living at par with any other cadre post. In the
But they
common
don't
body.
form a part of the cadre, but then also they are given the benefits of the cadre, but not the service benefits.
Right.
Now, kindly come to paragraph annexure 8 of the petition.
Lordship, it's probably basically like creating personal post, Lordship.
Personnel post.
Yes, Lordship.
But personnel also, you get service benefits
Yes.
because it is personal to him.
But
Kindly see
the
annexure 8, finance
doesn't
department
happen.
says this. Consequent upon government decision to normalize all posts under the state in during the current financial year, Iman, I am directed to request you to submit proposal to respective expenditure control branch of finance department after obtaining approval of the planning and development department as a part as an annexure year to duplicate to be retained in so and so. while identifying the post to be normalized, following aspects are to be taken. Only the filled up regular post created in the prescribed time scale with concurrence of the year and not the vacant posts are to be normalized. Employees identify GFF of the against the post. Now, how will these things apply? These must have come in at the time of the AIFRBM Act when the finance department took a stand. There he comes. Finance department took a stand that we need to take out certain some of the posts we are to reduce and now some posts which are to be continued. Isn't this? I think that was the time. That is why you see a reference to 2005-6. Yes, Mr. Chakraborty.
Think of any post under skill.
No, it can't have anything because it is to regular posts. So regular post also would be removed in view of this. Yes, Mr. Chakraborty.
My praise, Lordship.
What is your case?
Lordship, Lordship, the petitioners herein, they were appointed, Lordship, in the Fish Farmers Development Agency, Lordship, which was initially a centrally sponsored scheme. Lordship, subsequently, at that point of time, the sharing of the pay was 50% between central, 50% by the state. Subsequently, Lordship, the entire scheme was transferred to the state government, and the entire pay was given by the state government. The petitioners, they are being granted the same scale of pay as to the regular employees under the fishery department.
Huh?
Lordship, they are getting the same pay as is being given to the regular employees of the fishery
So
department.
getting the same pay.
Same pay.
Okay.
Now, Lordship, the only
So normalization has already happened.
the grievance which remains is they are getting the same pay. Those they are getting, but the retirement benefits
They won't get.
they are not getting that.
But how will they get the retirement benefits under the Assam Pension Code unless they come under Rule 31?
Now, Lordship, there were proposals sent twice because, Lordship, while these schemes were transferred to the state government, similar situation in Orissa it was done. Even in our state, under the health department, the centrally sponsored schemes which were under the health department, the staffs were serving therein, their services were also provincialized, normalized, and they have got all.
No, normalization is what? I don't understand the concept of normalization. Normalization means you get the same scale with that of the regular cadre. But normalization does not consist of getting other service benefits. So normalization may happen, which you are also getting it. Only thing is that you are not going to get those service benefits which a regular employee would get. That is the basis on which now you want it to be retrospective from that, so that from that point of time it will be counted. Now, how do you take care of the judgments of the case of Dhyan Singh, Parmeshwar Nanda and all, where you were never brought within the scheme of that?
Lordship, the employees under this scheme.
Dhyan Singh.
Lordship, this is centrally sponsored scheme. Lordship, these were implemented all across the country. Subsequently, those were transferred to the respective states. Now, Lordship, the persons were serving under this Fish Farmers Development Agency in Orissa regularized. Centrally sponsored scheme under the Health and Family Welfare Department of the Government of Assam. They have also been regularized, benefits have been paid. Lordship, even under FFDA, 2 persons have been regularized from their initial appointment, and they have also been given all the service benefits under the very same scheme of FFDA.
So that is a different case where there is a discrimination done for you for not regularization. But this court can't direct them to regularize. This court cannot grant them to regularize that. If some illegality has been done, it's a different thing. It may be an illegality committed by them. For that, have you challenged those appointments?
But we are claiming the same benefits which have been granted to them because.
So if they give some benefits for 2 persons, that means all the 100 people should be regularized.
Their case is because they are serving under the agency and they have not been regularized, therefore benefits cannot be paid to us. But under the same FFDA, 2 persons.
Show me any judgment of the Supreme Court whereby court has allowed this type of things.
Lordship.
Any judgment?
Is there, Lordship? Can give you.
Lordship.
If a person serves for 10 years, Lordship, or more, Lordship, and similarly situated person, even one is regularized, Lordship, and the benefit is assumed by the
employers lordship, then they are directed to be regularized lordship. The Supreme Court division bench has said that.
Where?
In one Rakesh Sharma lordship. that-
Old, very
No,
old.
It's a new one, recent 2023 lordship that came lordship.
So refer it.
Lord, I'll keep.
Yes. Tell me.
Lordship, now, Lordship, the proposal was already put forth. Proposal was put forth for regulation of the services of the petitioner. And Lordship, this post of CEO,
But that was rejected.
Lordship, the post of CEO, that has also been merged.
Huh?
The post of CEO, Chief Executive Officer of the FFDA, that was merged with the Fishery Department. The 12 posts of CEO which were existing in the FFDA was also merged. They have also been granted all the benefits. Now the remaining staff have been left out.
So isn't it within the ambit of the state? What can this court do? The state can do anything. That let them do anything. I'm not on that. But can this court issue a writ for that?
The Lordship will kindly say, under the Health Department, everyone has been granted. Under the same very department, 2 persons have been granted. Now, Lordship, if they cannot, in my humble submission, adopt a pick and choose manner, because under the Health Department, same centrally sponsored scheme, they have done. Here also proposal was there, but they rejected on the ground. that-
Which scheme?
Lordship, the centrally sponsored scheme. Look, under the centrally sponsored scheme.
No, no, understood. Health department, which scheme?
The Lordship will kindly come to. The Lordship will kindly come to page 89 for a moment. Page 89, Lordship.
Yes.
May I read?
Yeah.
It is clear that Health and Family Welfare Department has committed a serious irregularity by continuing the 3 centrally sponsored schemes, CSS, with Rural FW Center, Main Center, Transport Fuel, that is SHTO, under DSH, after they were discontinued by the Government of India with effect from 2002-3, 2002-3 and 2006-7 respectively. It is also seen that Health and Family Welfare Department has been continuing to propose budget provisions against this CSS, which on good faith Finance Department provided in successive years' budget. On detection of the above irregularities, the Health and Family Welfare Department has now proposed payment of salary to the existing incumbents and for continuation of the above 3 CSS as schemes under the state government. Now there are 2 issues. The immediate issue is payment of salary to the doctors, medical and non-medical staff who are working under these 3 CSS. Number 2, whether the CSS may adopt and continue to run those 3 CSS as state government schemes under non-planned budget. On this issue, it is left that since the central government have decided to discontinue the above 3 CSS nationwide, there is therefore ground to suspect that according to Government of India, in the above 3 CSS have outlived their utility. If so, continuation of the above 3 schemes or as non-planned schemes under state government does not prima facie appear to be necessary and justified. On the other hand, if the department feels strongly that the Assam's case is different and above 3 CSS are required to be continued as 100% state fund schemes, they may come up with adequate justifications. The bottom line is that the above 3 CSS may not be continued as state government funded schemes merely to facilitate payment of salary to the doctors and medical and non-medical staff. Now, Your Lordship will continue. In view of the above and taking into account the fact that the existing doctors, medical and non-medical staff under the 3 CSS were drawing their salary, Finance Department by its endorsement.
There are 2 options being given. Either these people may be adjusted against the vacant post or creation of posts by the Finance Department. Has the Finance Department created those posts?
Lordship, Your Lordship will kindly see paragraph 3.
That is what I read it.
Lordship,
This is written by the officer of special duty of the Finance Department to Health and Family. Now, the Finance Department has to create posts again. Have they created those posts?
Lordship, we have made a statement in our petition that Health Department has allowed that and they have been granted all the service benefits. Lordship,
Whom?
To the person serving under this scheme.
So this is the department, this is the government's thing. But can this court issue a writ?
But under one, Lordship, and Your Lordship will kindly see, these schemes were discontinued. In our case, the scheme is still continued. It was transferred to the state. It was never discontinued.
No, the scheme was you see, this is a policy of the government. The government may do many things in that regard. We have nothing to do out there. But the question is, can this court issue a writ that you regularize these people?
No, Lordship.
Your course is this. Now, in view of these new judgments out there, you are still enjoying the centrally sponsored schemes. Now, it is now a state-sponsored scheme. Now, the question if the state wants this, one question may arise in view of the Dharam Singh judgment, one aspect, that look here, their services are required. Why are you still not creating, bringing them within the ambit of the state and keeping them outside on the basis of a scheme? That is a question which may arise in the view of the Dharam Singh's judgment. But to get benefits, retrospective benefits is very difficult. Yes, Mr. Barbuzari, what do you say on that aspect?
Bandipura case is clear on the point, paragraph 26, which Narsingh has also quoted in my lord Purnima Bhure, that paragraph 26 is my lord. The principles will have to be formulated bearing in mind the position set out in the above judgment. Regularization is not a source of recruitment.
That I know, but read the last paragraph, last portion of the judgment, last paragraph, last portion of that paragraph.
Bandipura.
Bandipura page, paragraph 26, the last portion.
Perhaps be prudent to leave it to a claimant to establish whether he or she falls within the acceptance carved out in paragraph 52 and falls within the ambit of a scheme that may be formulated by the state. Subject to the riders referred to above, a scheme of regularization could fall within the permissible limits of Umadevi fee and be upheld. So that is one. But the division of this honorable court that in a interlocutory application had my lord passed an order that the court, this court cannot issue any direction for regularization.
Who?
The division bench of this honorable court.
Forget about division bench. The Supreme Court says in this case itself, paragraph 7, I suppose, of which I have quoted in Purnima Bhure.
Yes.
Bandipura, paragraph 7 or 9.
Paragraph quoted.
Two aspects.
Yes.
This is very important. Bandipura says there were two aspects which were decided in Umadevi. One, as to whether these people have a legitimate expectation that because of their long service. Second, as to whether under 226 the court can. Now, in that paragraph itself, the Supreme Court further said that not only the court cannot also direct that there should be regularized, the court cannot also direct that a scheme be formulated, because that would lead to again revisiting what was held negated by the Umadevi.
Because the regularization per se, my lord, is an administrative function. It is a legislative function. So the court may not step into the shoes of the government. So this is basically the reasoning.
But what do you say about that Dharam Singh judgment?
Yansing.
Dharam Singh. Dharam Singh's judgment says another aspect. Dharam Singh, Sivraj, Kirpal, all these things. These are all two judges bench, whereas Bandipura is three judges. Umadevi is five judges. Five judges. No, but three judges, these two judges who say another thing. That look here, whatever may be, you cannot, in the name of Umadevi, you cannot continue with these persons by not bringing them within the fold. And not bringing them within the fold by creating a post is subject to judicial review. You see, that is another development by which it just takes away from Umadevi. Umadevi says you cannot. Umadevi says you cannot, and paragraph 53 says as a one-time exception. Although the paragraph 53 has been interpreted in many times differently, that is one-time exception. Now, Bandipura further goes ahead and says recruitment, you cannot, the regularization is not a source of recruitment and all, this is an administrative decision and all these things. So from there, this court cannot direct, but this court can still question that after the central government left out from the scheme, you continued and you still continue. Means you need their services. And if you need the services, why they are not being brought within the fold of the government by creation of posts?
Now, my expectation will be the striking.
I cannot direct that you create posts. I can hold that the non-creation of posts to bring them within is illegal.
Yes. Now, my lord, so far as those decisions are concerned, the distinguishing factor is that, my lord, in those, my lord, cases, people were not working under scheme. Here is a case where people are working under the scheme. A scheme is a scheme. Cadre is a cadre. So therefore, mixing the service conditions per se, my lord, provided under a scheme with the service condition, regular service condition under a scheme. If the person is, my lord, included in the cadre means, my lord, he is under a statute. The service conditions will be governed by the rules and regulations. But a scheme is a scheme. Scheme is for a definite purpose. It is a project. Scheme is always for a project. And so therefore, my lord, Parameswar Nanda and Dhyan Singh, these two decisions speaks of scheme. So if it is in a scheme, you have to continue in a scheme. It is they who are happily continuing in the scheme. I could have perceived the situation if the petitioner, the same petitioner, let us assume a situation that these petitioners are not working in a scheme, but they are working in regular establishments, temporarily or whatever. Then, my lord, there's Dolly Borpuzari, logic in Dolly Borpuzari, reasoning in Dolly Borpuzari for a prolonged period of time, my lord. Perennial service, which we call perennial nature of employment. That may give.
So what is your stand as regards the scheme, the finance department stand? No, that I understand. As regards the scheme, the scheme. You see, because the payment is being made by the finance department. It's being routed through the finance department. Finance department's approval is there that this particular central sponsored scheme in the health department, this was discontinued and they were brought in within. These were the central government. Now what they have done, the central government, it was a central government scheme. Then it was partly payable by the state and partly by the central government. And now it is solely payable by the state government.
Yes.
Now, the finance department has given this approval for continuing of the scheme because without the finance department's approval, it cannot.
Yes.
Now, what is the finance department's therefore stand as to why it is required to be continued? Whether it is required to be continued?
Because, my lord,
Because that will give an insight that as to whether if you say that it is required to be continued, then why not bring them within the fold of the state? Or isn't it amount therefore amounts to depriving these persons of the pensionary or whatever benefits if they had to get it? Just for depriving them, therefore you are not bringing them within the fold of the state services. That is where Dharam Singh creeps in. No. Therefore, why you are allowing this scheme to be continued for all this time? Why the state government has taken up? Okay, we want it, and they have been continuing. Your finance department affidavit is not clear on that. You are just saying on Parameswar Nanda. Very well, Parameswar Nanda is there for that. They may not get the benefit of pension and all. There is no problem. But that is another thing. First is whether they will get a pension later on or not, whether that has to be regularized or not, that is another aspect.
Yeah.
But the question is non-creation of the posts.
Yeah.
When you are asking this, okay, you go on, continue, and thereby you don't pay. If you continue with this type of scheme in this regular manner, then in that regard, you don't have to even pay the pension. What not?
Yes.
Now, would it then be depriving with the very idea behind having a pension code?
It's true, but here Lordship is very easy because Lordship has made a reference to.
Mr. Chakraborty, I'll again ask you. Asking him that doesn't mean that I'm going to ask him.
Page 75. Sometimes you go Lordship has put a pointed code in was one of so first page 75 and next one 8. Page 75. Your finance has not yet filed its affidavit, but I am making my submissions on the strength of.
No, if you have not filed. No, you see, this is for the purpose of normalization.
And intent of this communication is to provide fund. It is only to provide fund.
No, you have to understand, this was done on 10th of May. At that point of time, the AFRBM Act came in.
It comes in the month of September 2020.
Understood. So prior to that, if I was taking up the Purnima Hore case, I have seen it. Prior to that, you start your process from, remember, the old pension, new pension comes on 10/2/2005. You're giving it effect from 1/2/2005. So therefore, the basic idea is you start to streamline your resources. Because of the fact that you have certain loans from the various authorities out there, now they have put a certain restrictions. So at that point of time, you want to take out certain posts which are outside. That is one there.
Bottom line is fiscal discipline.
At that point of time, the finances of the state was in very great turmoil. Now we hear the chief minister saying that we are having a 47% increase in the GDP. It's a 7 lakh crore.
It is correct. They did accept minor regularization, all the benefits.
I'm not saying a regulation. Why is it required that still now? Why are you still continuing with the scheme? Means are you in need? Therefore, are you therefore not taking away from the basic goal of the directive principles whereby certain benefits are to be given?
There is an administrative department in the fishery department. The
Fishery department
department-
can't. Fishery department wouldn't say anything. They have said that look here, we have requested the finance, and the finance use the word regrets. Finance said we are sorry. So therefore, the question is on that. What is your stand of the finance? Why are you continuing with these posts?
Then why not? I need to find my affidavit.
You have not filed your affidavit, so we will consider that the finance wants to continue.
But there are communications is the old matter, and it has gone for the file.
Now, let me tell all your councils out here, as I'm taking up this bench for next 6 months. So file your affidavits.
Yes. These are the-
Now bench 4 has escaped. The councils from bench 4.
We are offline. We are always offline.
No, because this 2015 matter, it doesn't look nice.
Actually-
But this is the pointed query to you. You have to file your affidavit on this point. Now, why you are continuing and you develop on that? It is not for me to develop. You are not developing in this manner. Find out that Dharam Singh's judgment, paragraph 8. It gives a very good insight. What is subject matter of a judicial review? Subject matter of judicial, this court cannot exercise, they direct them, okay, because my hands are tied in view of Umadevi. My hands are tied in view of Bandipara. But I can still question them why we are continuing with these jobs, all this, and why you're not getting them all benefits. Chalo, when should we get your affidavit then? Chalo.
Can it be the first week of February, my lord? I assume we will somehow get the affidavit.
First of week, I'm not there, so he has asked that.
No, my lord, any day, any day, fine.
Anyways, I should not delay all of you for that meeting and all. Then court will say. Chalo.
Any day, my lord, whenever lordship is sitting, my lord, any day.
Okay, no, you file your affidavit by 5th. You file your reply by 13th. And we have it on 19th. Huh?
19th of February.
Yes.
So,
This court heard the learned counsels appearing on behalf of the parties at length. Pusto. It has been submitted by the learned counsel appearing on behalf of the petitioner that the scheme in which the petitioners were initially appointed, recruited, was a centrally sponsored scheme whereby the central government was required to make certain payments, and the state also had to contribute. Subsequently, the central government handed over the scheme to the state.
Item 17, my lord.
You want to do it at 2?
My lord.
Oh, that is why I say anybody who wants to do matter at 2 can do it.
like to make a small submission before my learned and search. Not fully prepared with the case today.
Okay.
There for the phone.
Matter pertains to what?
Regularization of some ONGC workers and the fact started from 1989. Put the reference cases, several judgments, properly go through it and lie. The other said once Lordship allowed them to argue the case today. My response will be given the other or maybe tomorrow.
My lord, I may be allowed to make some small submissions, my lord. Some small submissions I may be allowed to make, my lord. Because he wants to give reply tomorrow or day after tomorrow. I have no problem. My lord,
This is against an award.
no, this is against an award. I have not challenged the award in full. I have challenged only one part of the award, where regularization is denied. My lord, initially there are 264 workmen, ONGC. They were not regularized, they agitated. Thereafter, they filed a writ petition, my lord, before the Honorable High Court. And in the meantime, appropriate government has also referred the matter. And reference was drawn up. And the reference was, and the award was in favor of the workmen, 264 workmen, my lord. And accordingly, there were 2 writ petitions before the Honorable High Court. One writ petition is CR 1907 of 1988, and another writ petition by ONGC, CR 4375 of 1991, my lord. Both these writ petitions were heard together, and a judgment was passed, my lord, by Honorable Justice J.N. Sharma. Common judgment dated 5/8/1993.
Where is it?
My lord, this is at page 47 is original. Type copy is at page 31. 31. By this judgment, my lord, the award passed by the tribunal was affirmed.
Okay.
Page 42 onwards, finding of facts are there, my
So
lord.
there was an award earlier.
Earlier, my lord. That
But
award,
that award has, what was the reference of the, where is the award? Let us see.
award, my lord. Award dated 18/3/1991.
What was the reference made? Whether the actions in not regularizing the services of 264 casual employees engaged in different actions is justified? If not. So this was the reference.
My lord.
So this reference, it was held that it was not the maintainable, it was not unjustified.
Unjustified.
And therefore the tribunal gave a finding at page 42.
Yes, my lord.
That so and so and so and so, Dhansi is not a temporary project but a permanent one, and Dhansi has started construction of Sound 21 here. From therefore, I find that a master and server exists during the ONGC. Therefore, I find that the concerned employees of here and they are not contractual workers. The management witness is so and so in the between opposition submitted by AI, it has been stated some 26 numbers have been appointed on regular at 37 so and so.
My lord, I have some small submission on this point.
Your small submission, I'll listen. First, let me see into it. Then the matter went to Supreme Court.
My lord.
Then there was a writ appeal.
My lord, before that, my lord,
Hmm.
I want to draw your lordship's kind attention to page 45 of the judgment, says judgment. Page 45.
Page?
45.
Yes.
Roman 3, first line. The name, designation, verification, and date of appointment of these workers is at annexure 10 of this affidavit in opposition. My lord, this is a part of the PDs. A long affidavit in opposition is filed by the ONGC, where the only crux of the affidavit in opposition is that we are not the part and parcel of the 264 members. This is the stand of the ONGC. We are not the part. ONGC has regularized some people without us. 37 people were left out. This is the case, my lord.
Only 37 out of 264 were left out.
Left out. And ONGC said that some 37 persons has left out is a fact. But we are not that. We are still working. My lord, presently we are not 37. While filing the case, we were 22. Others say somebody were died, somebody were retired, something like that. And presently, although we have filed it 22, list is at page, my lord, the list is at page 30A. Twenty-two persons involved in the writ petition, my lord. Page 30A.
So there is a Supreme Court judgment. Where is
My
the
lord.
Supreme Court judgment?
My lord, Supreme Court judgment is at page 65. Not 65. Yes,
What?
66, my lord.
This SLP is dismissed.
Is dismissed.
So against what SLP?
Against the judgment of the Honorable Justice J.N. Sharma.
So single bench judgment, it goes to Supreme Court.
My lord, at that time, writ appeal provision was not there, my lord.
Okay. That from a perusal of what was the award passed?
Award, my lord, at page 47, my lord, is just gone through. Page 47, no, page 31. This is the judgment by the Honorable Single Judge, Honorable Justice J.N. Sharma, my lord, page 31. And
No, where the judgment of Justice J.N. Sharma is in respect to reference case number.
Reference case number, my lord.
From 1991, accepting their demands. And reference case, rest of the year is so and so. The rest of the civil rule pending will rest on the decision of Iman. The terms of the reference are whether 264 are required to be regularized.
Regularized.
Now, this was held by the reference court
Yes.
as what? Kindly see number 3, page 37, down below, number 5. Services of all the 264 workers are to be regularized by the ONGC.
Yes.
This is the award passed.
Yes, my lord.
I've heard Mr. D. Talukdar so-and-so for ONGC and NM Lahiri for so-and-so. And this was upheld.
My lord. My lord. Upheld by the Supreme
This was upheld and thereby dismissing the writ petition filed by the ONGC.
Yes, my lord.
Isn't it?
Yes.
The writ petition was filed by whom?
Writ petition was filed by both the parties, my lord.
The workers has filed initially the writ petition and subsequently reference was drawn up
So the first writ petition was
By the-
that to regularize.
to regularize
But that regularization while was pending,
pending,
the reference was made.
my lord.
This led to a reference case where the reference court held that you are entitled to regularization.
My lord.
And a writ petition thereupon was filed by ONGC.
ONGC.
That ONGC's writ petition was dismissed, thereby upholding the award.
My lord.
So your earlier writ petition had become infructuous.
Infructuous, and although infructuous, court has held that although infructuous, but covered in the judgment, my lord.
Now thereupon the Supreme Court dismissed the appeal.
Appeal, my lord.
SLP was dismissed.
Dismissed, my lord.
Now what happened?
My lord,
Then why the second round?
my lord, second round, before going to second round, my lord, I may be allowed to,
In not regularizing the services of Indesto Soikia and 36 others as per the list enclosed and denying equal wages for equal work is illegal and so and so.
yes, my lord.
Answered the reference in favor of the and directed regularization of the 33 workmen if necessary in a phased manner. The aggrieved worker challenged the award through WPC. The workers have filed WPC number for implementation of the first award dated so and so and so and so. Both the cases are disposed of by the common judgment and so and so. Previous litigation. And what does this court hold? Interfere with the judgment dated so and so in Iman and also quash the award dated in consequence thereof the Iman is remanded back for adjudication afresh by the tribunal with due opportunity for both the parties. In deciding, CGT will base their decision on the evidence of the case and not be guided by so and so. A reference on the signal must decide the referred questions on the basis of that claimant. Here, what is noticed is that for the 37 claimant, the tribunal based the answer on the earlier reference according to this is how it can be said that the tribunal's decision was improper when the material was lacking in having the service status of the claimant was originally was left out on that. Now, kindly come to page 76. Paragraph 22.
My lord. Yes, my lord. Yes, my lord.
What does it say?
My lord.
Thus, without alteration of this conclusion,
Yes.
the second group of 37 cannot be counted in the original group of 264 workmen.
My lord, that's why, my lord.
Now, against that, did you file an SLP?
My lord, we did not file a SLP.
But the question
Where-
is,
where- because-
should this be the end of the road for the claimants without any redressal of the mechanism? Such result, according to us, will surely be harsh and so and so. So therefore, the division bench has come to a conclusion that these 37 were not a part of 264.
Right.
So therefore, you are saying that they were a part has already come to a close because of this.
My lord, only one thing.
That might be wrong.
My
Mr. Goswami, this,
lord, I may be wrong, my lord.
no, you are not wrong.
Yes.
The division bench may be wrong, but the fact that I cannot sit over this line, which is mentioned in paragraph 22.
My lord, that's true, my lord. That's true, my lord. But
So
I-
that
but-
thing
but-
which you have mentioned about that list is given in an affidavit to that.
But my lord, I may be wrong, but
Hmm.
I may be allowed to make a submission, my lord.
Yes,
My lord, page 45, please come again to the page 45, my lord.
yes.
The name, designation, verification, and date of appointment of these workers is at annexure 10 of this affidavit in opposition. The finding of fact of the honorable court. The court also shows the names were there. The names of these persons were there.
No, but how can I override this line?
My lord, kindly, that is my submission, my lord. I may be wrong, my lord. if this judgment is affirmed by the Honorable Supreme Court, that they are the part of the 264 persons, the in between the proceedings are a nullity, my lord. This is my submission, my lord. I may be wrong. I may be excused for it.
Okay, now let us go by that. This is one problem
This
which
is
you
this is
have.
my first submission, my lord.
Now kindly come to, this is one, and then this was remanded back.
Yes, my.
Now let's see the award.
And
Where is the impugn award?
and they are impugn award, my lord, at page. Award of page
179.
179. Yes, ma'am. Yes. My lord, may I read the whole award, my lord?
Not necessary. I don't read the whole award. Come back to the point. Only come to paragraph 11. Page 189. So your entire case is on the basis of this paragraph, whether it's a case of perversity.
My lord, kindly see that tribunal in the awards, tribunal came to a conclusion that it will be unjustified to
That's
dismiss
a different thing.
Yes, ma'am.
Kindly come to paragraph 11.
100.
89. So ANGC has challenged it on the ground that to continue them till their date of superannuation.
Yes, ma'am. Then
Mr. Desaikia, I think you should advise your client not to press this.
we are drawing 15,000 rupees per month. As on that, we are drawing 16,000 rupees, my lord. At the verge of retirement, my lord,
They have been working all this while, so they'll continue out there for these 15,000 for a big institution like ONGC. Anyways, let us see on paragraph 11.
the basic premises of the change. My lord, this Annexure 10, Annexure 10 was proved, my lord. My most respectful submission, that Annexure 10, which was part in the original writ petition, my lord.
But Mr. Goswami, you have a big problem with that line. That statement out there, that paragraph 22, the last line,
Yes.
very difficult. Because your entire case was on the basis of, entire reference case was on the basis of whether these 37 workers were left out.
Yes, my lord.
Out of 264. That was the subject matter of reference.
Yes, my lord.
Now, matter when that reference was there, the division bench came up and the initial award was passed in your favor, holding yes,
Yes, my lord.
they were a part of it.
2 hours, my 2 hours. 2
What
hours.
maybe? The first award, let us forget about this. First award says that 264 workers were required to be regularized,
Regularized.
and they were regularized or not. That's another aspect of the matter.
Yes.
But the second aspect is, which was the second reference, the scope of reference was that look here, whether these 37 workers were part of the 264. Okay.
Yes.
Now the matter was remanded back.
Yes, ma'am.
But while remanding back, there's an observation made by the division bench
Yes, ma'am.
that they are not a part of it.
But that's the case, my lord. This is I cannot use the word, my lord. I do not like to use the word, my lord. But I am not happy with this finding of fact, my lord, because
I'm also not happy.
That's
I'm
what-
not also happy, but the fact remains that that is the scope of reference.
my lord, kindly see records are there. Their names should appear. They were before the part and parcel, and Honorable Supreme Court has confirmed it. One contempt of court was, I do not know.
Contempt, then why didn't you move under 29?
My lord, I was not the advocate at that point of time, my lord. I am.
So now you have missed the bus. You cannot say that I was not the advocate.
Sometimes I miss the bus. Still, my lord, I am just hanging in the. I am hanging in the bus, my lord. I am not fallen down, my lord. I am not fallen down, my lord. I am just hanging, my lord. No, my lord, kindly see. There is a contempt petition in.
You do one thing.
In contempt.
No, Mr. Dev. You do one thing. Try to develop your arguments. Recently, I delivered one judgment.
My lord.
Try to develop your arguments on that. That was a case with some ONGC or no, not ONGC. What was that case? Isn't that additional industrial dispute sector? Wait, let me see if it is there or not. If you can develop your case on unfair labor practice.
Yes, my lord. I prepared the unfair labor practice, my lord. My lord, kindly give me the reference, my lord.
Huh? Or reference to that case. Wait. FCI, this one. A to DD hai. WPC number 2429/2020. Judgment delivered on. That was against FCI.
Yes, 2429.
He will give you a copy of the judgment on 2/12/2025. But you have a problem with paragraph 22.
My lord, I'll go by that. I'll develop it, my lord. I'll try to develop it, my lord. Paragraph 22.
Because and paragraph 22 and paragraph 11 of the impugned award,
Yes.
you have to show that it is perverse. Because here it says that apart the concerned workers also could not show that their status as workers of ONGC has been such that they deserve to be regularized. None of them could prove any appointment letters as casual workers. Admittedly, there is nothing on record to show that the present set of workers were engaged against regular vacancies. They were engaged on contractual basis without following any recruitment process. Accordingly, the action of the management in not regularizing the services of the present year cannot be held to be legal or unjustified.
My lord, I'll submit that Uma Devi's judgment is distinguished in this point, my lord. It is a special legislation industrial tribunal. Uma Devi's case will not come, my lord. And secondly, sure, that part of the no, nothing could have been proved, my lord. We do not possess the originals, my lord. The originals are with the ONGC. We file application. The court has, we file application, my lord.
But Mr. Goswami,
part
you have to also understand that this court's scope is way less.
That I have understood, my lord. That I have understood, my lord. That I have understood.
It's otherwise less and further curtailed by the division bench paragraph 22.
My lord, that's
This
true, my
has
lord.
become a very difficult thing.
These poor people, my lord, unless my lord will not exercise the jurisdiction. I know, my lord.
Poor people is very sad, but mercy is just outside the door.
My lord,
I'm otherwise very merciful outside the door, but not here.
my lord may not depend.
I only think that the ONGC should withdraw their petition.
My lord, kindly see, there is an order. There is an order of the tribunal. 15/11/2018, ONGC failed to produce the originals. We file application calling for the originals. ONGC's one witness came. He said that we have burnt out the originals.
Then the question is presumption,
We were allowed to prove the
secondary evidence.
secondary evidence. We proved it, my lord. That the court, the tribunal, the learned presiding officer came to a finding that we failed to prove it, my lord. We have all the witnesses, my lord. I have gone through. It is not that. Basically the list of Annexure 10, my lord, where our names were contained in the initial writ petition, my lord, that was affirmed by the Honorable Supreme Court. And the rest of the division bench judgment, my lord, I think my lord will be guided by the Supreme Court judgment dismissal, my lord.
Which one?
The SLP dismissed in 1994.
So what do you mean by SLP dismissed?
SLP dismissed in a writ petition. The Honorable single justice held that we were part.
Now, what do you mean by an SLP dismissed?
Judgment is affirmed, my lord. Judgment of the High Court.
Mr. Goswami, don't make that submission. SLP dismisses 136 court goes out there, seeks a leave. Leave granted, then it becomes a civil appeal.
Fine.
SLP dismissed that we don't grant a leave. We don't see there is any question of law involved. And as such, we are not going to look into it. It is a case of not entertaining. Then where is the question of dismissal or confirming? There is no confirmation. So SLP dismiss has no value. Be that as it may, there was a judgment, but the court has come to a finding out there that they are not a part of it.
So far, this case is concerned, my lord.
Yes, one thing I could see, but Mr. Goswami, I tell you one thing. This is a case, maybe a case of remand at best.
My lord, these people, they will be retired, all will be retired, my lord.
Can't help it. But the case is at best of a remand if I look into it, because what has happened, I cannot look into evidence and make any orders on the basis of, because you are exercising a tertiary jurisdiction. Tertiary jurisdiction, I can only quash it and say that this is bad, look into that. Isn't it the law?
In any way, if my lord is taking up the matter, may I go chronologically, my lord, as I prepared? May I go chronologically as I prepared, my lord?
Matters, let me tell you now the facts. Initially there was a reference which was made. In the reference was made, the question, what was referred, initially there was a tussle out there that there were 264 employees out there, they were seeking regularization, for which you filed a writ petition. When the writ petition was pending, a reference was made saying it to be an industrial dispute for not regularizing the services of 264. That reference was registered, and thereupon the learned industrial tribunal came to a finding categorically that they are required to be regularized. And pursuant to their regularization and pursuant thereto, the ONGC had filed a writ petition out there. The ONGC's writ petition was dismissed, whereas your writ petition had already become infructuous. Against that, an SLP was filed by the ONGC, that SLP was dismissed. This resulted into another dispute when 37 out of the 264 were left out. That is your case, which led to another industrial dispute, which was again referred. Another proceedings was registered. While registered, the industrial tribunal held that this 37 falls within 264, and thereupon the matter came up before the single judge. Single judge affirmed the award, and thereupon the matter came up before the division bench. The division bench, while remanding it, held that this 37 cannot fall within the ambit of 264. Be that as it may, we cannot be harsh enough not to give them anything. So let us again remand the matter back to them, giving both the parties some scope of any evidence to be given. And after evidence given or not, I am not aware, the award has been passed, wherein it says that you failed. Yes, it may be a case of perversity. But if it is a case of perversity, my action is to strike it down and again remand it. But anyways, you have a look at my judgment out there. Why I didn't remand it? If you can come within that. In that case also, I didn't remand it. Then I gave them certain benefits which you may get it. But you have to come up. But only problem you have to get out of this paragraph 22.
My lord, only one submission, my lord. My lord, I think after going through the records, my lord, my earlier counsel has failed to show the.
Mr. Goswami, don't
To
blame your earlier counsel. This is
Before the division, my lord.
blaming is wrong. Tomorrow somebody else will blame you.
But kindly see the records are there, my lord. They could have submitted the records. This is the records. The names were there before the report. That submission was not made, my lord.
Anyways, I think we adjourn the matter today.
My lord.
You have a look at the judge judgment. In fact, that judgment may help you out because why I'm saying this is similar. Initially, there was a reference made in that case with the FCI. When the reference was made, that reference ended in certain employees to be regularized. Some 94 or 97 employees to be regularized. Oh no, there was no, yes, there was a direction that kindly consider them in terms with a particular notification. Then the matter went to, they did not regularize these people, which led to a filing of a writ petition. When the writ petition was filed in the year 2017, there was a direction passed by taking into account Uma Devi. The court said, the same judge who wrote this judgment in your division bench said that we are not going to look into it, but it cannot be harsh enough. So therefore, we remand the matter back to the tribunal. For again, look into, we cannot be harsh enough. They can, however, raise such as per an industrial dispute. They were fighting for an industrial dispute. The industrial dispute happened in the year 2019 or 2020. When the industrial dispute happened, the court said that they are entitled to bonus, but they are not entitled to regularization. This led to filing of two petitions, one by FCI saying that they are not entitled to bonus, and the second is by these people saying that, look here, our prayer for regularization was rejected in the award. So in that circumstances, what I gave out there is bonus they are entitled to. Secondly, as regard regularization, taking into account the earlier judgment and all, I gave them. Because there were certain findings. But here we have some problem out there. Because you see, unfair labor practice is a case of discrimination. If there is a discrimination, then it is a case of unfair labor practice. So then I applied the principles which have been laid down in paragraph number 22 of Dharam Singh, why it is necessary that they should have been brought within a bit. You'll get it in this judgment. Have a look at it.
My lord, can
And thereupon,
can I make a photocopy of it?
this is a printed copy for you. Yes.
Easy, no?
And then you look into it if you can. But only problem, Mr. Goswami, is paragraph 22.
My lord. 22 of the award. And 11 also. my lord.
No, the division bench order.
Dividend bench.
What do you say, Mr. Saikia? Eh? That is very difficult for me to overcome. In fact, the remand should not have been made if it was that opinion, but I can't sit over that. It was something like yesterday I got one judgment. They had filed a contempt. The question was as regards whether there should be payment of pension to those persons who were working for long ages and all, on temporary basis and all. The Leonard Podnet bench rejected everything. And he is not entitled to everything. Yeah. Then one line is given, be that as it may. If the petitioner, if the respondent's department have engaged or regularized somebody or granted pension to others, the petitioners also shall be given. Now he has filed a contempt, so where is the finding to that effect? But this is how it is. This last line shouldn't have been given at all. Where is the question? After you have come to a categorical finding Because the reference was specific only as to whether these 37 were part of 2064. If that was the reference, it could not have traveled beyond that and said about harshness or not harshness. Because then the question of unfair labor practice would not come into being. If it was a question, because if you see the judgment, can I have a level? You have got the judgment? See the reference, how it was worded. The reference says whether it amounts to an unfair labor practice to leave out these 8 persons out of this 94. And I think I'm only keeping it out there. Take your instruction, don't disturb with what has been given out there. No, that filing another petition. Another petition has been filed, na? No. ONGC has filed?
No, not.
You are not challenging them, na? Oh, it's okay, very good. Then it was a case for dismissal right away today.
AG has also magnanimity, high amount of magnanimity. AG will help.
Here I am not the AG.
No, he's no AG. If it was a state government, yeah, I couldn't have. Yes.
Here, my job will be at stake.
Anyways, have a look at it if you
Why
can
not?
improve on that.
AG was seen, sometimes AG was seen, yesterday AG was seen with Amitabh Bachchan, today before this honorable court, my lord. AG is very busy, my lord.
No, that is the magnanimity of the AG, and it is for us, we are privileged to get.
My lord, I have seen, in the Assam is very dynamic,
Ah.
very dynamic Assamese.
Anyways, all these judgments won't do, but that is the only way how you can escape.
My
But
lord,
paragraph 22 is very difficult.
My lord may kindly give it, my lord.
Whenever you want,
My 28th of January.
without escaping paragraph 22.
Yes.
Otherwise, it will get dismissed.
22.
20.
Huh?
Hmm?
20.
28th January I am here.
20. Okay. Now, heard Mr. S. Goswami, the learned counsel, appearing on behalf of the petitioners, and Mr. D. Saikia, the learned senior counsel, assisted by Mr. N. Anik Singh, appearing on behalf of the ONGC. Pustup. This court heard the matter and have also perused the records. Pustup. The question which arises in the instant proceedings is as to whether the findings given, findings of the learned division bench in its judgment and order dated 29/9/2016 in writ appeal number 96/2013, more particularly at paragraph number 22, would have any impact on the findings which impact on the present proceedings. Mr. Goswami, you see another judgment which I am telling you, see on a case of remand. When a case is remanded, what happens to the proceedings? What happens to the findings? Whether it will be binding? Because there are 2-3 Supreme Court judgments on that aspect. List the matter on 21. No,
20.
20?
Yes.
No, I fixed it on 20.
Deeply applied.
No, today I'm having it whoever wants to do the matters, because I've been told there was a representation to the Chief Justice that kindly asked Justice Borua to accommodate. So I said, okay.
There's the reference.
My lord, it will be a part-heard matter.
Don't worry, I'm sitting on 20. It will come before me.
High level.
item 15.
Huh?
15.
Yes. What is that?
It's a matter pertaining to pay parity.
Huh?
And medical officers Ayurvedic. Worship, what had
Homeopathic and Ayurvedic. What is happening to that Ayush matter in the Supreme Court? There was a review file.
No, that dismissed. Review dismissed. No, that issue is settlement.
The issue is settled.
PA Bhatt case.
Huh?
PA Bhatt.
There was a review file, no?
That-
referred to larger bench.
That is what
That
something.
is
else.
pending. That has been referred to larger bench.
Another bench have referred it to a larger bench. On the question as to whether they should be given the same pay parity and all.
That was between allopathic and Ayurvedic. Here, Lordship, it's between Ayurvedic are already in the state of Assam. Ayurvedic are getting the pay scale of the allopathic doctors. The homeopathic section has been left out. Even though there was a recommendation by the Sixth Pay Commission that both are entitled to the same pay. Ayurvedic they have granted. Homeopathic.
Who has given the recommendation?
Lordship, the Pay Commission, Sixth Pay Commission had recommended for same pay scale of MO Ayurvedic and MO homeopathic, medical officer Ayurvedic and homeopathic. Ayurvedic, the state government has granted them, but homeopathic has been left out. Now, Lordship, the affidavits say, health department says we have submitted everything to the finance, but they are raising question, finance say health department has not submitted us.
Finance who appears?
Now, Lordship,
The issue is, madam, financial section, madam, certain credits were sought for. And madam, they were requested to resubmit it again. That is it. And by now, madam.
And then what do you say about what the health department says?
Health department says, madam, that it was submitted, but it was reverted back by the time.
Now, have you, when finance has said, tell me, wouldn't it be a conflict when you are appearing for both? Huh?
Stand of the authorities, but nobody has got a help. This is not the stand of the health department and finance has rejected it, so we cannot pay.
No, the fact, therefore, one thing is very clear, that without any adjudication by this court as to whether they should be entitled having the pay, their work being same or not, there is already a pay commission, an expert body, who has recommended the same pay scale.
Only for Ayush, not for whom.
No, given for both. That is what it is.
that the Lordship will find that.
That is what Mr. Chakraborty has said. That the pay scale for Ayur and homeopathy,
Page 40, Lordship, 40.
page 40 is the same. So therefore, I need not go into all the other normally where we have to go into all these things.
I'm sorry, Lordship, page 41.
Page
41, Lordship.
The commission recommends all medical officers, Ayurvedic, medical officers, homeopathic, who have undergone graduate degree of 4 and 1 year MBA at par with allopathic counterparts and be placed in the PB4 of so and so.
But they are diploma. Para
Huh?
2. Lordship will say para 2.
The diplomas.
Lordship, diploma also, your Lordship will see there is a, no, Lordship.
However, diploma holders, homeopathic will be placed in PBN3.
Lordship, this is by the association. There are both diploma and degree holders, and there is a decision by the state government that diploma of 4 years duration will be treated at par with degree.
Huh?
Diploma, that your Lordship will.
So that is by the state government.
State government as well as by the central government. That because Lordship, what the issue is, prior to 1984, there was only diploma course in existence.
Mr. Chakraborty, were you making this small bit submission in that regard? Because you initially made a submission that there is a recommendation for treating both of you equal.
Lordship, because
But the recommendation makes it very clear that the diploma holders cannot be put at equal, they will be in PB3.
association contains, because the association is before your Lordship, the association contains both diploma and degree holders, which is why I had made that submission. The second part, as regards diploma holders, that I will have to satisfy your Lordship, whether they will be entitled to the same pay as the degree holders or not. But as regards the degree holders are considered, that recommendation is there by the pay commission.
Where?
Lordship.
Where is that the government has
Lordship.
accepted it?
Lordship. That your Lordship will find page 53 by the state.
Pursuant to the letter and taken by the central government in its meeting, and the governor is pleased to equate the diploma conferred by an authorized institution with 4 years study, including the period of internship, with the degree conferred by an authorized institution, including a second schedule to homeopathic so-and-so in economy, would be considered effective only for the purpose of pay parity and not for any other purpose. Oh. What do you say on this?
Not taking to page 43 for a moment. He has referred to page 41.
Now he has referred to page 53.
No, possibility page 43. What was the recommendation specifically in case of health department on this issue by the government?
Yes, where?
Page 43 annexes this.
Yes. May examine feasibility of various recommendations regarding parity for Ayurvedic and homeopathic with allopathic doctor in pay and allowances, pay of diploma holder, Hirman, etc., and submit a proposal to the finance department with a detailed justification in the light of 1.59 of the commission. Now,
Page 40. This process is normal. Financial statement manner pursuant to this, proposal should come from the health department.
with respect to the many important recommendations detailed of so-and-so was not found in our report in view of the possible ramifications of recommendation on intersect. Now, these recommendations were made when?
Lordship, this was
Huh?
2008.
2008.
Lordship.
And pursuant thereto, this notification has come
Lordship, 2008.
only for pay parity, page 53. This is by the Health and Family Welfare Department.
No, it equates the manner diploma and degree. Pay parity is different manner.
No. Finally come to page 53.
Yes.
In so-and-so, in its meeting held on so-and-so, governor is pleased to equate so-and-so conferred by so-and-so institution or for and so-and-so. These equivalents would be considered effective only for the purpose of pay parity and not for any academic purpose. So therefore, for pay parity, the governor of Assam have done it. Now the question is, when the governor of Assam has done it, it speaks not only for the health department, it also speaks for the finance department. Can the finance department say that no, this governor is only for the health department? No. So therefore the state has to speak in one voice. And when the governor have done it on the basis of the health and family welfare department, it is deemed that the finance department's approval has been taken. Unless the finance department says that the governor doesn't know anything. Which I hope they won't.
Number is not there. Five is number 9. Filed on 10/7/2015.
It's an old matter. Matters of
Planning base 58.
58, I believe. Lordship.
respondent number 9. Ah, got it.
Nursing is 61. The relevant part.
Submitted initially proposal for allocation of uniform response for so and so. After examination of health and family welfare was requested to wait till submission of your anomaly report. Subsequently held for enhancement of the scale of Ayur. In this result, they have submitted the case of the Iman. After examination, department allowed the pay scale of the Iman equivalent to allopathic doctor. Since the case of medical officer Homeo was not submitted by the health aid, so it was not possible. 2010 approached the network with the proposal. This time the head was requested to examine the proposal as per Iman. Health department again approached again with the proposal of allowing the pay of Iman to along with him. But this time also they found the documents in support. The department was requested to furnish information authenticated. But so far as the finance department received the But this is filed in 2015. 10 years have gone by. Mr. Wu, I am very disappointed with this bench. 2014-15, so many matters pending. I think now my prime focus should be these matters. Every day, 3 matters or 4 matters of 2014 finishing. Every day. No, this is not done.
Yeah, for instruction, this will be helpful for other cases too, madam. To my knowledge, madam, there is some statement from the government that the pay commission will be constituted or has been constituted. If that be so, madam, this all things will be referred to the pay commission. When you are constituted, because 10 years they will last. From 15 to.
I'm told that the 8th pay commission is being constituted.
That notification can.
But what will happen is they are not asking for retrospective things.
No, that they are not.
So you are asking for equation.
Can be taken. Not only this case, but lots of cases will come up from this.
Yeah, you find out. We have it on 20. Get your instructions on that. This is and because you see, after all, when governor have already put that for pay parity, it is very disturbing how on earth the state have not, the finance have said that no, we are not going to look into that. And more particularly, unless that notification is fake or fraudulent, you cannot say nothing else. The finance cannot say this has not been done, that has not been done. It is obviously you cannot reject. It would be undermining the powers of the governor. There's one judgment, no? The state should speak in one voice. You have it?
Today I don't have it.
Yeah. Okay. Chalo. So we do one thing. 20, I have fixed the other matter. Na, that is also going to get dismissed. 22nd. Huh? No, I can have it on 19th, I'm not sitting. 21st, I'll have it. On 21st at 2 p.m. to get an instruction as to what is to be done. You are a diploma.
It consists both diploma and degree holders. This is the
You
association.
are having diploma and degree.
Because the association is.
Heard Mr. A. Chakraborty, the learned counsel, appearing on behalf of the petitioners who are medical officer homeo, who consists of medical officer homeo, both degree and diploma holders. The grievance of the petitioners herein are that in spite of the recommendation made by the 6th pay commission that a medical officer homeo pay should be in parity with medical officer Ayurvedic and medical officer allopathic bracket, Ayurvedic bracket. The petitioners have not been granted the benefit. Full stop. The learned counsel appearing on behalf of the petitioner further submitted that though in the recommendation it is mentioned that medical officer homeo, who is a diploma holder, would be placed at pay band 3. But on the basis, but by the notification dated 19/7/2011, issued under the name of the Governor of Assam by the Health and Family Welfare Department of the Government of Assam. The diploma holders who have been conferred diploma by an authorized institution with 4 years study course, bracket excluding the period of internship of bracket oblique housemanship, bracket close, is equated with the decree holders by any authorized institution for the purpose of pay parity. Pustak. This court have also taken note of the affidavits which have been filed by both the Health and Family Welfare Department of the Government of Assam as well as the Finance Department of the Government of Assam. From both the affidavit, it transpires that the Health and Family Welfare Department have equated the degree holders with that of the diploma holders and have also submitted proposals to the Finance Department in terms with recommendation clause, in terms with clause 1.59 of the recommendation of the 6th Pay Commission, recommendations of the 6th Pay Commission, so that the medical officer homeo, both diploma and degree holders, have pay parity with medical officer allopathic. On the other hand, the affidavits which have been filed by the Finance Department submits that the Finance Department have not rejected the proposals, but have returned back seeking further additional information. Next. It is disheartening to take note of that the instant writ petition has been pending for the last 1 decade on this issue. And it is high time that both the Finance Department as well as the Health and Family Welfare Department pulls up their socks so that the recommendations so made can be given effect to. More so when the governor of Assam, in exercise of his powers, in exercise of his executive powers conferred by the Constitution, had issued the notification dated 19/7/2011. First, list this matter on 21/1/2026 at 2 p.m. for an update.
Right. The equivalence is only for the pay parity, that part.
That is what only for pay parity I mentioned. But this needs to be finished up. It can't go on like this. Ask for.
Item 18.
Anybody wants to do? If nobody wants to do, no problem. Everybody wants to do. Yes.
My lord, in this case, my lord, we agree by the impugn order at Annex 12, my lord. Page 57 onwards, my lord.
Annexure?
Page number 29, my lord. Annex 12, my lord.
What has happened?
My lord, actually, my lord, that he overstayed leave, my lord. He was granted leave, my lord, for a period of 2 months, my lord. But he did not join his duty, my lord. He was supposed to join his duty on 18/12/2019, but he could not join his duty, my lord. And as a result, my lord, there was overstay of, according to them, 352 days. And my lord, the reason was that, my lord, he was at that time suffering from mental illness, my lord. That is the main ground, my lord. And in the month of April, when he went there, my lord,
How many years of service you have?
he joined in 2003. Let me say birth one is there. Birth. I am sorry.
Against that, have you filed appeal?
Yes, we have filed appeal, my lord. There is an extra 13, my lord.
Huh?
An extra 13, my lord. 38 years.
Where?
Page number, my lord.
Appeal, what happened?
Appeal, my lord, we do not know about the outcome, my lord.
Huh?
When we filed the case, at that point of time, till that, it was not disposed of, my lord.
What happened? Rejected.
Was rejected on lordship 30/10/2021.
Why have you dismissed him?
Was the Ohio's the league lordship for 352 days lordship. It is the reason lordship. He was declared the wizard lordship.
The main thing is that, my lord, at that point of time, I was suffering from mental illness, my lord. We have already submitted all the documents, my lord, to show that he was not in a position, my lord, to join his duty, my lord. He was not in a position to communicate with any person, my lord. And as such, my lord, I could not join, my lord. But they have not considered the provision of the Person with Disability Act, my lord. My lord, I pray that if compulsory retirement can be imposed, my lord.
Huh?
If compulsory retirement can be imposed, my lord. So he will get some benefit, my lord, at least.
If you are removed from service,
The removal will not.
you will get the pensionary benefits.
Removal, I think, I think I won't get, my lord. Only if compulsory retirement, my lord, then only I will get.
Compulsory retirement is one of the punishments.
Yes, one of the punishment. Because mentally he is, my lord, now.
Where is your certificate?
My lord, we have.
Nagaon BPC.
We have, my lord, submitted various prescriptions, and the medical certificate also is at page 23, my lord.
Page?
Page 23. Page 23.
When were you depression?
My lord, depressive neurosis, something like that, my lord. It is a type of mental illness, my lord.
He is found physically and mentally fit.
That
and
was
good.
in my lord, 2011-2020, my lord.
Okay. Now, when were you, when was the impugn order passed?
In the month of April, my lord, April 2021.
21. Did you submit this document?
We have submitted the documents, my lord, when we filed the appeal, we submitted the document. And after.
When did you submit this document?
First, my lord, in the month of April, my lord. In the month of April 2021, when he went to join his job, my lord, he submitted the documents, but those were
You
not.
come now, sir. You went to join the job on month of April 2021.
Yes, my lord.
You submitted this document.
Yes, my lord.
Then what happened?
Then I was asked to leave, my lord. That they told me that you are being dismissed, and so you can leave. So at that point of time, my lord,
are not eligible. Informed that the man with Then,
my lord, they did not also even supplied me the copy of the impugn order, my lord. Then I submitted RTI, my lord. And your lordship will see in the RTI reply, that is Annexure 11, my lord.
so it was done behind the back.
Yes, my lord.
Notice was not issued.
So cause notice was not issued, my lord.
What?
So cause notice was not issued. They have admitted in their my lord, RTI reply, my lord. I am coming to that RTI reply, my lord.
Where?
I am Annexure 11. It starts
It
from
has
page
been
24
informed by
onwards.
so and so dated demand that the so-called
Serial number
was
3, my
not
lord.
issued to before the year. However, so and so had sent to your home address that you may submit your written statement in defense within 15 days of the receipt of the notice. The report of the inquiry officer and a copy of the final pass are already being handed over to you. A copy of the final order passed of the departmental inquiry is again sent to you. Okay.
After I submitted the RTI, then thereafter, my lord, they handed me the, my lord, the impugned order, my lord. But when I was initially dismissed, my lord, nothing was given to me. So my lord, I would like to only point out that, my lord, he was not in a mental state, my lord, to decide what to do and what not to do. He was unable to understand anything, my lord, at that point of time.
What is the date of the show cause notice?
They have shown it as 14/6/21, my lord. But he was dismissed on April, my
Okay.
lord, 2020.
Mr. Gugoi, you have the records? Huh?
Just sent to his home address. Just sent to his home.
You don't have?
It was sent to his home address. So person was.
In the Hindi also, my lord, 14/6 is given.
We have the record. We have the record.
In the Hindi version, my lord, that is given also. It is
So is
shown-
it required to issue a show cause or a show cause is there?
It is there.
How do you proceed out here? And this is under the CRPF.
CRPF.
How do you proceed?
So the procedure prescribed in the section 11 and 27.
Yeah, how do you do it? You have a court of inquiry?
Dorset, court of inquiry is not known.
Not this. Then it is being done. There is another provision. I was doing one matter in Kohimat matter case course.
Appointed as like our deputies. Even army is court of inquiry is conducted with.
There is 148 or something. I forgot the section. No, rules. Where the disciplinary proceedings, how it started?
Which starts from section 8, rule section 8. Procedure of punishment is proceed rule 27 also. Effect of procedure declaration disaster rule 31 also. इसमें एक rule 31 court of inquiry party there also before declaring disaster also.
Yeah, the procedure is given here.
Does rule
27.
does it?
Rule 27.
27 is there also email also in respect to minor indicated court of inquiry.
When non-gazetted officers or men of various ranks are to be punished for an offence, a departmental inquiry, if necessary, under clause A shall be held by the commandant or the superior officer under the order area, provided that when the charge is against an officer of the rank of Subedar. Your rank was?
A constable, my lord.
Below. Or Iman shall be held by authority to be designated by Iman, where the officer conducted the inquiry in the case of Iman. The substance of the accusation shall be reduced to the form of written charge, which should be in a precise, charge should be read out to the accused and a copy of it given to him at least 48 hours before the commencement. Now, does this rule say what happens when he is not present? If the accused has pleaded guilty, it's so and so.
For that, Lordship, Rule 31 regarding declaration of desert terms.
If a member of the force shall be liable to trial under Iman of the Iman or member of the so and so does not return of his own free will or not apprehended within 60 days of the commencement of the desertion, absence or overstay of the sleep, then the commandant shall assemble a court of inquiry. So I said the court of inquiry. You had a court of inquiry. Court of inquiry consisting of at least one gazetted and 2 members who shall be either superior to inquire into the abstention so and so. Court of inquiry shall record the years. So therefore I ask you, where is the court of inquiry?
It is there. Court of inquiry.
No, court of inquiry is different from disciplinary proceedings.
Court of inquiry is respect of declaration of desert terms.
Yes. So did you hold it?
We have declared it. That.
No, where is your court of inquiry? Because I remember once when I was doing a matter in this departmental inquiry.
Which is on Lordship. Record is here, Lordship. We have the record, Lordship.
Where is the court of inquiry report?
In the report.
Subsequent to the passing of the order for department accused or Niman, a copy of the remembrance.
Issued Lordship. After that, Lordship, he was declared deserter.
So he appeared on 11/12. Your name is Madhav Das.
Madhav Das.
You appeared on 11/12/2020.
As per our instruction, my lord, he went there in the month of April. But
Preliminary hearing of the official was done on that day. Since then, the official remained present. Since then, official remained present before the inquiry officer till the completion. So you presented it.
Sir is there, everything is received.
Then?
No, my lord. Actually, he was at that point of time, my lord, he was unable to understand anything. He only informed us that only in the month of April he went there, and after that he was.
No, your case is that he has approved in the month of April. That cannot be true, taking into account that you participated. So you knew about the inquiry, what was going on.
And even if it's
then,
my lord, even if
That
it's
is-
considered that he's participated, my lord, that at that point of time he was suffering from mental illness, my lord. So he did not.
the mental illness is subsequently.
No,
Did you
mental-
take that plea out there?
My lord, mental illness, we have taken the plea in the appeal, my lord.
No. It can't happen like this.
In the appeal, we have taken that mental plea. my lord.
Chalo.
And my lord.
We do one thing, we'll have it some other day then. And whereupon the accused pleaded guilty to the charges framed against him in the article of charge.
Even Lordship himself.
Then,
And even Lordship he denied the cross-examination of the other part witness also. In written, his signature is there, he has pleaded guilty, after guilty, his signature is there also. All documents he has.
because I remember there is a requirement.
Comment in respect of declaration of disaster, this is key one. Otherwise, even without going through also, they can proceed. Here, Lordship, all procedure was.
And you should have got some certificate from whom have you got this certificate? Who is this particular person who has given this?
Apart from mental disease, it should be reported also mental hospital also. Which is also PHC also.
PSC, what is the PSC doing?
Public health.
No, actually, he has went to the PHC, my lord, on several occasions.
What
my lord.
PSC? Where is the certificate again? Who has given? subdivisional medical health officer, how is he, how can he give depression? And this was on 2011-2020. At that point of time, you why did you get this document? And join on 24-2021.
He went.
Anyways,
April, my lord.
no, that case, we won't dismiss it now. We have it on. When?
Immediately, as per your protocol.
Let's have it on 27. 29.
Before 27 or after 30 lawsuit.
Okay. Let it be on 3rd. 5th. I am also not there anyway. This is the matter on 5/1/2026. Before 27, there is no date. No? 19 to your Advocate General took the date on 20. Then your Additional Advocate General took the date on 21. 22. Okay, Thursday, 2 p.m.
Right.
But Mr. That day, I'll dismiss it. First week, I'm giving some relaxation.